Good morning, everyone. This hearing is called to order, and thank you all so much for joining today. My name is Shekhar Krishnan. I'm the chair of the Committee on Oversight and Investigations. First and foremost, I would like to thank Speaker Julie Menin for entrusting me with chairing this crucial committee and my colleagues for serving on this committee and joining us today. I'd like to thank my co-chair for today's hearing, Councilmember Salvina Brooks Powers, who is the chair of the Committee on Criminal Justice. And additionally, thank you to the representatives from the Department of Investigation, the Department of Corrections, the members of the public, the advocacy group, legal services lawyers who are here, and my council colleagues who have joined us today. Joining us from the council, my colleagues are Councilmember Sandra Ung, Councilmember David Carr, Councilmember Frank Morano, Councilmember Gail Brewer, and we've also been joined by our public advocate, Jumaane Williams, and former Councilmember Jumaane Williams. And Councilmember Caban has joined us online as well. This hearing comes for us at a perilous moment in our country right now, and right here in New York City. Donald Trump and the federal government are testing over and over again in an egregious way the limits of our city sanctuary laws. They have tried all different tactics, from Tom Homan appearing on Fox and Friends with former Mayor Eric Adams, promising to be, quote, in his office, quote, up his butt if Adams didn't deliver on his promise to let ICE agents operate in Rikers Island, to raids on Canal Street, to the horrifying conditions of 26 Federal Plaza, and the incident just last week where a Columbia University student was taken from her dorm after 5 DHS agents entered under false pretenses and no warrant. In addition, we have seen over and over again from communities across our city the raids and enforcement actions from ICE spreading fear and terror in our neighborhoods. These are all actions of a federal administration trying in every way possible, at any cost, to erode our sanctuary protections. Every single story of escalating force has been an attempt by the federal government to undermine our laws and to cause fear in our communities. Our sanctuary laws protect immigrant New Yorkers. They help them feel safe coming to city government for services, from health care to help with housing to care for their children. It's for that reason that city agencies should be working for us, focusing on the needs of our city, delivering for New Yorkers' needs, and keeping us safe. And they should not be taking on federal immigration responsibilities, collaborating with ICE, and increasing the fear that we all feel every day. When our sanctuary laws are violated, as the Adams administration did and tried to do repeatedly, they leave immigrant New Yorkers terrified, afraid to seek out help from the very city government that exists to serve them. And let's be clear about what our sanctuary laws do in our city. Our sanctuary laws are designed to make sure that city agencies do not assist with the enforcement of federal immigration laws. City agencies are prohibited from using city resources to cooperate with federal immigration authorities. And law enforcement agencies like NYPD, DOC, and the Department of Probation, DOP, are prohibited from complying with detainer requests from ICE except when there are a limited number of public safety circumstances. But we are a city government focused on carrying out city responsibilities and keeping New Yorkers safe. That is distinct and apart from the purpose of the federal government and immigration enforcement by the federal government. If New Yorkers feel like their city agencies are aligned with Donald Trump's mass deportation campaign, if New Yorkers feel like our city government is simply an extension of the federal government when it comes to immigration enforcement, New Yorkers, and especially immigrants, will not trust our government, and they will not accept help from emergency services, for example. I have seen this in my district alone, where residents displaced from their homes were too scared to speak with government offices or city agencies that were ready to help them. Where New Yorkers were too scared to leave their homes, take their children to school, attend parades for Lunar New Year, or break fast in their masjids during Ramadan because they may be harassed or taken by ICE. These are very, very real fears, and they are playing out every single day in our city. and it is unacceptable. Today's hearing is about reaffirming that our city agencies should be working for New Yorkers, not for ICE. This hearing builds on the work of prior Council Speaker Adrian Adams and Councilmember Gail Brewer, and to them I am grateful. Today, we will be examining the Department of Investigations reports on agency compliance with New York City's sanctuary city laws, and holding agencies that have collaborated with ICE accountable for when they have violated those laws. The report found deeply concerning instances of DOC impermissibly collaborating with ICE enforcement. Corrections officers, as the DOI report found, violated the city's sanctuary laws through information sharing with federal immigration authorities about at least 2 individuals in DOC custody. In fact, this collaboration went so deep between DOC and ICE that one individual whose information was shared and who was apprehended by ICE was featured on a White House X post where they bragged about, quote, making America safe again, quote, with his deportation. This report from DOI finds that corrections officials had unwittingly breached the law because they also had not been properly trained on when and how to share information with federal authorities. Another report found that an NYPD officer had violated New York City sanctuary laws and that the NYPD does not fully comply, quote, with documentation and reporting requirements, end quote, regarding interactions with federal law enforcement. The DOI report made 7 recommendations as to how DOC and NYPD could improve its compliance with the city's sanctuary laws. NYPD accepted all of those recommendations. DOC, however, accepted some, but not others. It is time, under a new mayoral administration, that we correct the dangerous course charted under Eric Adams, our former mayor, when it came to the treatment of immigrants in this city. A crucial part of breaking from that past is to make sure the egregious actions of the recent past, the violations of city sanctuary laws, or the close calls never happen again. I know that this administration under Mayor Mamdani shares this vision, as does his newly appointed Corporation Counsel, Steve Banks. So at today's hearing, our committees will question DOI about its findings, the status of the agency's implementations of DOI's recommendations, and DOI's assessment of whether the NYPD and DOC are complying with legally mandated documentation, upholding reporting requirements, and properly training officers on how to handle interactions with immigration authorities. Our committees will also question DOC about the steps it is taking to comply with the city's local laws, to train its officers on relevant legal requirements, and to correct the violations of the past. We need to know what the agencies are doing. Today, we will learn 2 things. 1, is New York City prepared on paper and in practice to defend, to the fullest extent of the law, our sanctuary laws against a lawless federal administration? And 2, are our agencies prepared on paper and in practice to protect immigrant New Yorkers? We must be ready to meet this moment. We must correct the serious transgressions of the prior administration and make sure they never happen again. And above all, we must defend our rights and protect immigrants in our city so they feel safe. Before I conclude, I would like to thank the following council staff for their work on this hearing. From our O&I committee staff, Nicole Kata, Erica Cohen, Alex Yablon, and Owen Katowski. From the O&I division staff, Meg Powers, Kevin Frick, Zachary Mayer Casayas, Brian Parcone, and Yoni Kurtz. And from my staff, Chanel Martinez, Hunter DiVinagracia, and Victoria Opperman. And to everyone who's working in the background to make this hearing run smoothly. And no new council members have joined yet, but I'll make sure to recognize them when they do. I will now turn it over to my co-chair, Councilmember Brooks Powers, for her opening statement. Thank you.
Thank you and good morning. I am Council Member Sylvina Brooks Powers, Chair of the Committee on Criminal Justice. I want to thank Chair Krishnan for co-chairing today's joint oversight hearing on the Department of Investigations report on agency compliance with sanctuary-related local laws, and thank everyone for being here. I know that our colleagues have already been acknowledged. So New York City has enacted a series of sanctuary-related local laws over the past decade to establish clear boundaries on how city agencies interact with federal immigration enforcement. These laws were adopted to protect civil liberties, ensure that city resources are used appropriately, and maintain trust between government institutions and the communities we represent. The reports issued by the New York City Department of Investigation review how agencies, including the New York City Police Department and the New York City Department of Corrections, have implemented and complied with these local laws in practice. The findings highlight areas where policies were followed, but also where gaps in training, oversight, and reporting may have created risks of improper cooperation with the federal immigration authorities. Today's hearing is an opportunity for the Council to better understand the scope of the Department of Investigation's work, including the methods used to identify incidents and the measures taken to ensure that city agencies fully comply with the law going forward. We will also be examining the policies under the Department of Correction regarding sanctuary protections and their compliance under the law. Oversight is a core responsibility of this council, and it is important that we examine not only individual incidents, but also the systems and safeguards in place to prevent future violations. We will be asking the Department of Investigation about how these investigations were conducted, whether additional reviews may be necessary, and how agencies like the Department of Corrections are implementing the recommendations outlined in the reports. We will also hear from agency representatives and advocates to understand how policies, training, and internal controls can be strengthened to ensure consistent compliance across departments. This hearing is not only about reviewing past incidents, it is about ensuring clarity in how our sanctuary laws are interpreted and applied, improving coordination between agencies, and reinforcing accountability when civil liberties are violated. I would like to thank my staff and committee staff for their hard work: Chad Benjamin, policy analyst; Jeremy Whiteman, senior counsel to the committee; Casey Leisky, financial analyst; Julian Martin, my deputy chief of staff; and Renee Taylor, my chief of staff. I thank everyone who is joining us today and look forward to a thoughtful and constructive discussion about how we can strengthen compliance with sanctuary-related local laws and maintain public trust in our institutions. Thank you, and I'll return it back to Chair Krishnan.
Thank you so much, Chair Brooks Powers. And now we are going to hear an opening statement from our public advocate, Jamani Williams.
Thank you, Mr. Chair. As mentioned, my name is Jamani Williams, public advocate for the City of New York. I want to thank Chair Krishnan and Brooks Powers and the members of the committee for holding this important hearing. New York City is home to more than 3 million immigrants, and this is diversity of tapestry of people that makes our city so special. That doesn't include most New Yorkers who are born from from immigrant parents. That number is even higher. If you go to grandparents, even higher, more than that. Immigrants are our friends and families, our teachers and business owners and civil servants, our neighbors and friends, and so much more. And right now, they are under unprecedented attack on their civil and human rights, and each of us have a responsibility to protect. Similarly, city sanctuary laws are also under attack. New York City has had laws in place that limit how the city can interact with federal immigration enforcement since 1989, when Executive Order 124 was first enacted by then Mayor Ed Koch. City agencies are prohibited from sharing information about immigrants with federal officials unless they are suspected of criminal activity. ICE is not allowed to arrest immigrants at a courthouse or other state government facilities, and the NYPD and DOC are barred from honoring quote-unquote detainee requests from ICE, except in certain limited circumstances. Despite all of the fear-mongering about sanctuary cities, these laws make us all safer. These protections allow immigrants to report crime and serve as witnesses without fear. They do not protect criminals. They don't now. They never have. It has never been about protecting criminals. It is about protecting New Yorkers who live here. Despite New York City's clear policies about when and how local law enforcement can cooperate with federal immigration enforcement, several recent incidents where it appeared that NYPD violated our sanctuary city laws have raised serious concern. In response to City Council request for an investigation, the Department of Investigations published a report in December of last year. In one of those instances, DOI included that the NYPD had violated sanctuary city laws by accepting a request from the Department of Homeland Security to set up a system where the officer would be alerted if a person facing deportation interacted with the NYPD. Though the information remained internal to the NYPD, this is still a violation of the law. Further, DOI found that in all of the instances, an NYPD did not fully comply with documentation and reporting requirements for their interactions with federal law enforcement. The new details included in the report highlight some of the gray areas in the city's sanctuary laws. Though it is naive to think that no local enforcement officer would knowingly violate the law, the other 4 incidents in the report where DOI concluded there was no violation show that this is not a black and white issue, and there are potentially even more incidences that we do not know about. DOI issued 7 recommendations to the NYPD in this report, which the department thankfully has accepted. And still, with the ever-present threat of full-scale federal invasion, as we have seen in Minnesota, looming over us, the administration and NYPD must ensure that they provide clear information, protocols, and training to its officers and supervisors on how to comply with sanctuary laws and try to eliminate gray areas as much as possible. Gray areas at this time creates fear for folks and is dangerous. This must also be paired with real consequences for officers who violate the law. Interaction with federal law enforcement is inevitable, and the NYPD, as well as DOC and other city agencies, should be fully equipped to follow sanctuary laws, and supervisors should be equipped to assist when officers have questions. As DOI points out in the report, all federal law enforcement agencies now have some hand in immigration enforcement, so there must be additional scrutiny on all collaborations with federal law enforcement. As I have often said, now more than ever, we must hold tightly to each other and not let go of anyone's hands. While we're seeing abhorrent behavior from the federal government, it is imperative that we hold ourselves to the highest standard. Just as importantly, hold each other accountable when there are missteps or willful acts of bad faith. As we've seen in last week with the Columbia kidnapping of a student, there's no lows that this administration the federal administration won't step to, including lying. Every person in our city and in our country has inalienable human and civil rights, and we cannot let the inhumanity of this president erode our own humanity. And I'm very thankful that we have a new administration. The last administration was morally and ethically bankrupt, in my opinion, and was trying to welcome this federal invasion into our city. I'm very thankful that we have a new administration, a new mayor, who has a more moral and ethical thought and agrees that we should be protecting New Yorkers. And I'm hoping that we can get agencies to back that up with actions and accountability. Thank you.
Thank you so much, Public Advocate. We've also been joined by Councilmember Alexa Aviles. As with my prior committee, I believe with this one as well, that in our public chambers, when we have a hearing, it is important to hear from members of the public, and not only for us as a city council to do so, but for the agencies and government officials who come to testify as well. I think that is an important part of making sure our government works better and serves all New Yorkers the way that we should. And I think it's a crucial component of oversight as well. So on that note, before we hear from our city agencies, I'd like to call up our panel of legal services lawyers who are doing this work on the ground every single day, to hear from them what they are seeing, what they are hearing. That panel, before we go over to our agencies, are from the Bronx Defenders, Rosa Cohen-Cruz, Sophie Dulcimer from Brooklyn Defender Services, and Sarah Venzulis from the Legal Aid Society. Thank you all so much. Each of you has 2 minutes, and Rosa, we can start with you.
Thank you so much. Chair Krishnan, Chair Brooks Powers, all of the committee members here today, thank you for having us here. And thank you, Councilmember Brewer, for initiating this investigation. And thank you for allowing those of us on the front lines to testify so that the Department of Corrections can perhaps greater understand just how harmful their conduct has been over the years. My name is Rosa Cohen-Cruz. I'm the Director of Immigration Policy at the Bronx Defenders. And in 2014, the City Council enacted these laws in recognition of a fundamental truth that when local law enforcement collaborates with ICE, it erodes trust and undermines public safety for all New Yorkers. And if you look at the hearing record from 2014, you hear from domestic violence survivors survivors, gender justice organizations, public defenders, and members of the public who all shared that how critical it is to have these protections to ensure fairness, due process, and make sure that all residents can access agencies without fear. These laws have existed for more than a decade without real oversight and meaningful enforcement, and unfortunately they have been routinely violated, and one of the worst actors has been the Department of Corrections, which appears before you today. In February 15th, 2023, and again in December of just last year, we, along with my defender colleagues, testified about the many ways that the Department of Corrections not only has blatantly violated the law, including information obtained through the FOIL, which showed them illegally communicating with ICE using the hashtag #TeamSendThemBack, but also acting in ways that undermined the spirit of the law or obscuring their actions to violate the law. For example, undertaking the practice of slow walking our clients out when they had notified ICE that someone was going to be released. So even though under state law they're not allowed to hold people past the time that they would be released, they take on these actions to create delays. And when asked by the council or when submitting testimony about these delays, they repeatedly said that accounting for the timing would be too arduous for them. Just to make one last point, they've asked us to just believe them that they're going to follow the law, and the council has kind of continued to do so, and yet again and again we see violations. And at the 2025 hearing where we were aware of violations, the department failed to even show up to account for them. So we're at a moment where we need clear guidance. We need this kind of oversight to continue to really investigate, and I'm hoping that with this new administration we will see the agency really act under the values that the new mayor has put forward. But I also do hope that this council will put forward an accountability measure like Intro 209, the New York City Trust Act, because unfortunately these assurances fall flat. We've been here year after year telling the same stories, the real harm to our clients. My very last point, and I know I'm at time, is there are two questions or two interpretations of law that I hope this council will ask the Department of Corrections to examine. One is what is their interpretation of law that allows them to transfer custody of individuals with the qualifying convictions without a judicial warrant being presented. They have testified in the past that they have transferred individuals but never been presented with a judicial warrant. That's from their own words. And I would like to know if that's still the case. And number two, they seem to read Admin Code 9131 to allow them to make transfers of people based on the instant arrest, even though the plain language of the statute says that the person shall not be considered to have been convicted of a violent or serious crime unless that person has a judgment entered against him on the crime within 5 years prior to the date of the instant arrest. So those are two interpretations that they enact, that two ways that they seem to be violating the plain text of the statute that I think demands greater inquiry. Thank you. Apologies for going over time. I appreciate all of your attention this morning.
Thank you.
Thank you all so much. My name is Sarah Vinzulis. I'm the director of the Immigrant Justice Team of the Criminal Defense Practice at the Legal Aid Society. I'd like in my testimony to explain through the story of one of our clients why the recommendations in the DOI report are insufficient and why true accountability is needed. Because this client's been deported to a country where he feared harm and persecution, I'll refer to him with a pseudonym. Our client Brian.
Sorry, do you mind moving the mic a little bit closer?
Of course.
Thank you.
Sorry. Our client Byron was a young man seeking asylum. He was arrested after a fight between him and some other young people. His defense attorney negotiated a plea that would leave him with a youthful offender adjudication. The goal of this plea was to preserve his ability to seek humanitarian relief in the form of asylum and special immigrant juvenile status. While Byron was at Rikers with pending criminal court charges, ICE lodged a detainer against him. But despite the detainer, he was eligible for release from Rikers because the detainer law specifically exempts YO adjudications from the definition of a violent or serious crime. When Byron's defense attorney reached out to DOC for assurances that he would be released, as the law requires, they were non-responsive. The attorney even specifically asked DOC if they were aware that YO adjudications do not count as violent or serious crimes, and DOC's response was merely, "We will follow the law." Relying on that, we advised Byron that he was getting out of Rikers and soon, since he was almost done serving his sentence. But rather than follow the law, DOC turned Byron over to ICE a day before he was to be released, and we still don't know why. Of course, we requested all the applicable files, documents, and communications between ICE and DOC, and any determination relating to his eligibility for release, but there was nothing in the file that explained why they turned him over. There was no judicial warrant, and there were no gang or terrorism markers, nothing. The two things that this exemplifies are lack of transparency and lack of accountability. First, there was a complete lack of transparency from Doc the whole time. He was never even served with the ICE detainer, which is especially problematic because the detainer itself on its face says that it should be personally served on the person affected. In fact, Doc has never been willing to give us, as counsel, a copy of our client's detainer without a lengthy FOIA request. So when Doc is even less transparent than ICE, that's a problem. Also, it's extremely problematic that Doc refused to do any analysis of whether or not they were going to cooperate with ICE until the day of release. This left us no time to intervene on his behalf and advocate for a proper application of the law. And unfortunately, this problem is also not unique to Byron. In Byron's case, Doc refused to even engage with us about what the law means and how they interpret it, and completely ignored our analysis. We even asked them to confirm that they were aware that YO adjudications were protected, and they told us, you can file a FOIA request to get our guidance. So as you're aware, those take months to be processed. So, if we had known that this was going to happen, we would have done things completely differently. We would have been able to inform Byron what to expect when he was detained. We would have been able to tell his family that he wasn't coming home that night. We would have been able to make sure that he had phone numbers memorized and that his family knew how to get in touch with him and track him. We would have gotten him to sign releases so we could figure out why he was transferred. And we would have worked to make sure that he had a lawyer. Every step along the way is the opposite of transparency. Additional training and reporting are not enough. And finally, one really, really quick point I want to make is that, in his case, we were lucky. He stayed in the New York City area. He was able to get an attorney. Most clients, will be transferred now to Texas, to Florida. I was able to get him to sign releases. I got the doc file, confirmed that Doc violated the law.
Just ask that you conclude.
Oh,
soon
yeah.
if you can.
But the point is, there's no incentive for Byron to do anything about this. He's in another country. If his name gets in the media and the news, on Fox News, it could end up on Fox News. He's at risk. He's putting himself at risk. He's putting his family at risk. So, when I speak to him, I'm hoping to get in touch with him, I won't be able to say, listen, Byron, let's investigate this. Let's find out what went wrong. Let's find out, let's hold them accountable. There's nothing in it for him. And so I think there are more Byrons out there because there's no true accountability when Doc violates. Thank you, and apologize for going over time.
Thank you.
Good morning. My name is Sophie Dalsimer. I'm an Associate Director of the New York Immigrant Family Unity Project at Brooklyn Defender Services. Thank you to the committee chairs for the opportunity to testify today. New York City's sanctuary laws are intended to limit local involvement in federal immigration enforcement, but the DOI reports highlight deeply concerning incidents in which these laws have been violated. The reports should serve as a warning that city agencies are unable to consistently comply with laws that have been in place for a decade. A central concern is the persistent lack of understanding among city workers about what sanctuary laws require and what conduct is prohibited. Frontline staff are often placed in situations involving immigration authorities without clear direction. This confusion is not incidental. It is the result of agencies failing to provide adequate guidance, training, and internal protocols to ensure compliance. Our experience representing New Yorkers reflects these gaps in implementation. We have encountered repeated situations in which Department of Corrections staff incorrectly refuse to release individuals after bail is paid based on the mistaken belief that the existence of an ICE detainer requires continued detention, even where the individual is clearly protected under city detainer laws. As a matter of law, an ICE detainer alone does not provide a valid basis for continued detention once a person has met the conditions of release. And this misinformation can deter families from posting bail, unnecessarily prolong incarceration, and increase the risk of immigration enforcement. This example and those shared by my colleagues highlight the need for consistent compliance and greater training and guidance to all agency staff. Another critical issue raised by the DOI reports is the need for greater data privacy protections. City agencies routinely collect and maintain large amounts of personal data through everyday operations, including benefits, housing, through NYCHA and law enforcement databases. Our policing technologies also generate detailed records about New Yorkers' movements and activities. These systems often contain inaccurate or incomplete, unverified information, yet they can have significant consequences when relied upon by law enforcement or federal authorities. And I'll just conclude by noting that the New York NYPD's gang database is a striking example of the overcollection leading to harm. It's well documented that this database disproportionately targets Black and Latina youth, and that the criteria to justify placement are unscientific, pretextual, and racially coded. Despite these serious flaws, it's been
Just ask you to
documented
conclude soon, sorry.
that NYPD has shared this information with Department of Homeland Security, essentially ensuring that a racially biased and error-prone database has become a vehicle for exposing New Yorkers to federal immigration enforcement. This council should enact new and strengthen existing policies that keep communities' personal data private. Thank you for your time, and I welcome questions.
Thank you for your testimony. Just one brief question for Rosa, and I'm assuming speaking collectively for the entire panel here. Is it your testimony that these violations, both reported in the DOI reports, the ones that you've seen with your clients as well, does it make your clients, do you feel it makes immigrant New Yorkers feel unsafe coming to city government to access services far beyond whether in the criminal justice system, but everyday services from government?
Absolutely. I think that's really at the core of what these laws are all about. We also, we know that there has, for example, been a decrease in reporting like wage theft violations because a lot of construction workers in particular may have vulnerable immigration status. And so even where the city tries to enact measures to make everyone, for affordability, to make everyone feel safer, those measures can't always land with immigrant communities because they hear about agencies violating the law. They hear about agencies like DOC, NYPD, and others sharing information, and it makes them afraid to go and report crimes and report harms against themselves. So not only is it undermining, public safety and our ability and everyone's ability to sort of engage in civic society, but it also is undermining some of the very critical agendas that this administration has put forward.
Great. Thank you so much for your testimony, and we appreciate all of your work in the city too. Thank you. Oh, sorry. Does anyone else have questions for this panel? No, I just realized. Sorry. Okay. We're good. Thank you. I also want to note that we've been joined by Councilmember Yusuf Salam and Councilmember Kevin Riley. And now we will call up the representatives from Department of Investigations and the acting commissioner for their testimony, and I'd ask the committee counsel to swear in the witnesses once they're seated.
Thank you, Chair Krishnan. We will now hear testimony from the administration. We will first hear testimony from the New York City Department of Investigation, Acting Commissioner Chris Ryan. Before we begin, I will administer the affirmation. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth before this committee, and to respond honestly to council member questions? Thank you. You may begin when ready.
Good morning, Chair Krishnan and the Committee on Oversight and Investigations, and Chair Brooks Power and the Committee on Criminal Justice. My name is Christopher.
Commissioner, if you mind just moving your mic a little bit closer.
Sorry?
You do. Thank you.
How's that? Better? My name is Christopher Ryan, and I'm the Acting Commissioner of the New York City Department of Investigation. I appreciate the opportunity to provide testimony on the two reports DOI issued in 2025 regarding the City Department of Corrections and the New York City Police Department's compliance with the sanctuary city laws, the local laws that limit how and when city officials can assist with the enforcement of aspects of federal immigration law. These laws and related city policies restrict local authorities' ability to share information about an individual's immigration status, bar city law enforcement from honoring ICE detainers unless specified conditions are met, and prohibit city agencies from assisting with immigration enforcement. It is important to note that following DOI's reports in 2025, the city's sanctuary laws and policies were updated earlier this year through Local Law 63, which broadened some key definitions such as federal immigration authorities and immigration enforcement, and barred federal immigration authorities from maintaining offices on Rikers Island for any purposes, and through Mayoral Executive Order 13, which prohibited the use of city lots as staging grounds for non-local law enforcement operations, among other changes. DOI's investigation resulted in 2 public reports focused on specific allegations involving DOC and the NYPD, and presented New Yorkers with our findings and the details of the violations that DOI substantiated. These reports also explained the importance of the recommendations we issued to strengthen agency policies and training around these laws, which were passed to encourage undocumented immigrants to report crimes, seek medical help, and access other essential services without fear of deportation. DOI's investigation relating to the NYPD began in response to a letter from then Speaker Adams and then Chair of the Oversight and Investigations Committee Brewer on June 9, 2025, which raised questions about potential violations of the sanctuary city laws in 2 incidents. DOI reviewed these 2 incidents and found a 3rd incident during a review of media stories raising similar fact patterns to the initial 2. The NYPD alerted DOI to a 4th incident, and a 5th incident was uncovered during DOI investigations. Collectively, these incidents provided a diverse survey of how the city's sanctuary city laws are implicated in the work of the NYPD. The DOC investigation began as a result of a February 2025 complaint received by DOI. The results of DOI's limited review of officer conduct and the broader findings of the investigation determined that 1 DOC task force member assisted with immigration enforcement, but was not aware that the information provided to federal authorities was in furtherance of civil immigration enforcement and thus impermissible. DOI also found that DOC was not training personnel on how to engage with immigration enforcement or officials, or issuing sufficient guidance about the city's sanctuary city laws. For both reports, DOI conducted focused investigations and issued recommendations to the NYPD and DOC so those agencies could take any necessary corrective actions and implement any needed measures to ensure compliance with sanctuary city laws that would prevent further violations. DOI also recommended that DOC and the NYPD conduct internal audits of their interactions with federal immigration authorities. I believe the findings of our reports lay the groundwork for the audit efforts announced in EO 13, titled Protecting New Yorkers from Abusive Immigration Enforcement, which, among other provisions, requires 6 city agencies to develop and publicly communicate policies and protocols regarding their interactions with immigration enforcement authorities on their websites, and to implement training for their employees, contractors, and subcontractors. These agencies, specifically the Administration for Children's Services, DOC, the Department of Health and Mental Hygiene, the Department of Probation, the Department of Social Services, and the NYPD, are also directed to conduct compliance audits of relevant sanctuary laws and to produce a report on their findings. In addition, the EO supports employee and public education efforts on the laws and regulations surrounding the city's interaction involving immigration enforcement, an important element raised in our reports. If the audits uncover wrongdoing or allegations that sanctuary laws and/or policies have been violated, they should be referred to DOI for further investigation. Let me turn to the findings of DOI's reports. In September 2025, DOI issued its reports on an investigation into a DOC Intelligence Bureau investigator assisting federal agents with immigration enforcement that was prompted by a complaint to DOI. The complaint to DOI alleged that DOC officers assigned to a joint task force provided assistance to immigration and customs enforcement agents in February 2025 in connection with the arrest of an individual in DOC custody who is believed to have entered the country illegally. It is important to note that except in very limited circumstances, DOC staff cannot consent to a request from a non-local law enforcement agency for assistance or support to further civil immigration enforcement or to provide assistance or support. However, it is permissible for DOC staff to participate in task forces with other goals, such as bringing charges, even if that work has the potential to have impact on an individual's immigration status. DOI's investigation found that a DOC investigator assigned to the Homeland Security Investigations Violent Gang Task Force did in fact provide assistance in violation of city law and DOC policy. During the investigation, DOI uncovered a second incident where the same DOC investigator provided information to federal immigration authorities about a second person in DOC custody, also in violation of city law and DOC policy. In both instances, DOI determined that the DOC investigator was not aware that the information provided to federal authorities was in furtherance of civil immigration enforcement, rendering the DOC officer's actions impermissible, as opposed to the inquiry actually being in furtherance of a federal criminal investigation, which would have been permitted pursuant to local law and DOC policy. DOI also found that DOC had not provided adequate guidance or training to DOC personnel with respect to DOC's rules and procedures for interacting with law enforcement agencies involved in immigration enforcement. DOC was also not providing any training to its officers or staff about city sanctuary, city laws, or DOC's policies issued pursuant to those laws. Moreover, the requests for immigration enforcement assistance related to the two persons in custody were not reported to the Mayor's Office of Immigration Affairs or posted on DOC's website as required by law. DOI issued 7 recommendations to DOC to strengthen their practices, including providing updated guidance to DOC employees on the city's administrative law relating to immigration enforcement and on how to respond to requests for from law enforcement partners, instructing DOC staff to direct any immigration-related requests from other law enforcement authorities to DOC's ICE unit and the General Counsel's office, conducting a department-wide audit to determine any other identifiable instances where DOC, unintentionally or otherwise, assisted in immigration enforcement, and in accordance with New York City's administrative code, reporting any previously unknown or unreported immigration enforcement-related requests to the Mayor's Office of Immigrant Affairs. DOC accepted 4 of the recommendations, implemented 2 of them, partially accepted 2 recommendations, and is still considering 1 recommendation. DOI will continue working with DOC to ensure implementation of the recommendations that DOC is accepting. In December 2025, DOI issued its report into the NYPD's compliance with laws restricting city assistance with immigration enforcement. DOI examined 5 incidents and identified 1 instance where an NYPD officer violated local law by providing assistance to federal authorities in connection with enforcement of the federal civil immigration law, found that the NYPD does not fully comply with documentation and reporting requirements set forth in the sanctuary city laws, and also found gaps in the NYPD's current policies and practices that increase the risk of improper assistance to federal authorities for purpose of civil immigration enforcement. Broadly, DOI found that the NYPD has been working diligently to ensure that its policies comply with local laws, while still permitting critical partnerships with federal law enforcement on criminal investigations. DOI concluded that the NYPD's current policies and procedures, particularly as strengthened and enhanced by a series of policy reforms that the NYPD implemented in 2025, both before and after DOI began its investigation, comply with city law. As a result of the investigation, DOI issued 7 recommendations to improve the NYPD's policies and practices, which the NYPD agreed to implement. We appreciate that the Council has shown its commitment to the same goals embodied in our recommendations in its recent enactments as well, for example, by requiring that the NYPD scrutinize requests for custodial transfers from all federal agents who could be enforcing immigration laws, not just from immigration authorities. The NYPD recently reported that they are moving forward with their effort to implement our recommendations. On the recommendations that call for the NYPD to require enhanced review of all custody transfers to federal agents, to adopt a standalone policy on requests for custodial transfers, to improve policies for processing requests for assistance from federal agents, and to adopt guidelines to implement Local Law 246, which restricts non-local law enforcement officers from city property under its control. NYPD has established a working group that is in the process of drafting new policies. On the recommendation that the NYPD provide further training to its officers and employees on how to comply with sanctuary city laws, the NYPD is currently discussing the correct structure for its supplementary training. And finally, to better understand the NYPD's compliance with local laws, DOI recommended that the NYPD conduct an email audit of NYPD members assigned to federal task forces to ensure their compliance with local law. The NYPD has reported that the audit and a proper structure for that audit is under active discussion. Our reports provided much-needed transparency on incidents of concern involving 2 city agencies' compliance with sanctuary city laws, and offered numerous suggestions as to how compliance could be improved moving forward. I thank you, and I'm happy to answer any of your questions.
Thank you so much, Commissioner, for your testimony. I have a few questions, then I'm going to turn over to my colleagues as well, then come back to my co-chair and my colleagues, then we'll come back to me as well. Oh, and we've also been joined by Councilmember Oswald Feliz on Zoom and Councilmember Susan Zhuang as well. I read both reports that the agency put out last fall, and I thought they were both excellent and really went through what had happened. And what was also shocking to me, too, is we've had hearings on this issue. We've known this has been an issue. But sometimes I don't think it's fully known in the public just the extent of the violations and how close we came to violations by, yes, those within the agencies unwittingly, but also because of a city hall under the prior administration that was eager to cooperate with ICE in any way possible. And so there were some serious instances there that you all documented, and those that we know about or that were stopped along the way. But stepping back for a moment, I think it's also important to really ensure that our public has an understanding of what our sanctuary laws are. They are complicated, they operate in different ways, but they serve a very crucial purpose. So my first question is, just taking a step back, can you explain for everybody, what are the sanctuary laws in New York City and why are they important?
So there are a combination of both laws and mayoral executive orders that can constitute what we refer to as the sanctuary city laws. And broadly speaking, these are laws enacted to prevent city law enforcement and other city agencies from cooperating with federal law enforcement for the purpose of civil immigration. Exactly as I think you said in your opening statement, to encourage New Yorkers whose document status may not be compliant with federal law to feel free to come forward, to use city services, to engage with law enforcement, and to become, to be full participants in the life of the city without fear that some interaction with city government will compromise their ability to live their lives here in New York. It's obviously, as to the second part of your question, it's obviously very important. I was a prosecutor for 20 years here in Manhattan. If in the criminal context, if witnesses do not feel comfortable coming forward, that would be a terrible consequence of people's fear of federal immigration law.
And that was my follow-up question, is conversely, when the sanctuary laws are violated by city agencies, you would agree, right, that they would have a chilling effect on New Yorkers, immigrant New Yorkers coming forward to, if they're victims of crimes, to report to law enforcement crimes, if they need help accessing emergency medical services from government. You would agree that those violations would have a broader chilling effect on New Yorkers in the city, am I correct?
Unquestionably.
Now, understanding that framework and the report that you all did your investigation reveal, let's start with the Department of Corrections, for example, whether DOC had any written protocols for handling unsolicited requests from federal agents prior to your recommendations? Because part of what we're seeing here is there wasn't, despite the guidance, there was not training, that line officers may not have known what the laws were. Did they have protocols in place? And what did your investigation reveal about that for both DOC and for NYPD?
Yes, and so both agencies had protocols in place. The point of failure was the dissemination of those pre-existing protocols down through the agencies to the people who would be the ones who really needed to know. It's fine for executives to know the law, but the people on the front lines of the agencies who are most likely to interact with and need this information were not. That information was not being disseminated effectively down through the ranks, and I think our recommendations. Part of the purpose of the recommendations was to make sure that pre-existing policies and any new policies that comply with city directives, when they get developed, are pushed down through the agency to everybody who needs to know them.
And what are the timelines the agencies have shared with DOI about implementing these recommendations?
So I don't believe we have necessarily. We're in continued communication with both agencies. I don't believe we have any specific timeline for them. NYPD has broadly accepted all of the recommendations and has made significant, as I said, very diligent changes to their policies and the manner in which they disseminate those policies through the rank and file. That has been a very effective to date. DOC, we're in communications and a constant, continued dialogue, both with the outgoing administration and now with the incoming DOC executive staff to clarify any points of our recommendations that perhaps were not particularly, that weren't either understood or any further guidance we could give on why DOI thinks that those recommendations were important. And that is also a continuing dialogue. I don't have any particular time frame.
Does DOI have you all given consideration to creating some sort of mechanism to ensure the agencies are reporting back to you all on a more concrete timeline of when they're making these recommendations and how they're doing so?
Yes, we are speaking with the agencies as on an ongoing basis. We are, have been talking to the administration as well to provide some other perhaps structure for all of our policy and procedure recommendations that DOI issues across the board to all agencies to come up with perhaps enhanced mechanisms for follow-up and implementation. So the answer is yes.
And you noted, and I also want to recognize that we've been joined by Councilmember Lee as well. You also noted before, too, that the different agencies adopted the recommendations to different degrees. NYPD, all recommendations. DOC, I believe you had said 4 accepted, implemented 2. I also noted that recommendation number 6, for example, in the DOC report, the recommendation was the agency conduct a department-wide audit to understand the extent of potential violations or violations within the agency. And DOC responded that such an audit would be impractical and that the agency would consider targeted reviews. Now, that was classified as a partial acceptance, not a rejection, but I do want to understand a bit more of which recommendations by DOC were implemented, the 2 that were implemented, And this one that was rejected or partially accepted, how you characterize it, what was the reason given for that? Don't you believe that's an important one for them to do as well?
Yes. So the two that were accepted and implemented was DOI's recommendation that DOC instruct all DOC staff to direct any immigration-related requests from other law enforcement agencies to the ICE unit and the General Counsel's office. That was both accepted and implemented. The second is DOI's recommendation that DOC instructs senior officials to confer with senior officials at the federal partner agencies with whom DOC staff regularly collaborates to remind them that DOC staff is bound by city law and cannot assist in civil immigration enforcement under very limited circumstances. Those were both accepted, and I believe those conversations have happened. As to number 6, the recommendation for a broader audit, I mean, I would refer you to DOC's general counsel for a specific answer to that. I believe it was something to do with the manner in which that audit would be rolled out. And I think in many ways that recommendation has been supplanted, might not be the word, but overtaken by the work that we know Senior Advisor Mostafi is going to be doing at the mayor's request for all 6 agencies. So DOI's recommendation was again a recommendation to DOC, but I believe the Senior Advisor Mostafi's audit, which is essentially, I believe, what DOI had originally recommended for DOC, will be conducted, and so in some ways that will accomplish the recommendation that DOI issued.
Mm-hmm. And just a few more questions before I turn it over to my co-chair. DOI had its investigative reasons for targeting certain limited circumstances that were reviewed. I believe 5 email accounts, or at least 1, and finding 1 correction officer had improperly assisted federal agents. You had your own process too for what you reviewed for NYPD as well. From what you all reviewed, first, why were those incidents chosen? And number 2, from your findings, do you all have reason to believe or reason to be concerned that the violations or potential violations may be broader and more pervasive within both agencies, particularly DOC, given the lack of training that you all found?
Yeah. Cool. Hold on, one moment. So the staff at DOI, we are New Yorkers, and we read the same media reports that all of you do and your constituents do. And so both professionally and personally, we are as concerned about what we're seeing nationally as anyone else, both I think as individuals and as an agency. To your question of I think the manner in which we approached the investigations in both instances were to provide substantive response to the council, both responsive to Council Member Brewer's letter and the Speaker's letter, and to give the council as substantively valuable and expeditious response to give an insight as to what's going on in both agencies, as opposed to incorporating, for instance, a type of audit that Special Advisor Mostafi will be conducting, which will take a significant period of time. So we were balancing a substantive response to the council that would provide immediate, or immediate, but reasonably quick insight into what's going on in both agencies and to make recommendations in near real time while we were seeing the situation in the country devolve as it goes to in relation to immigration enforcement. So there was a balance there. One of the reasons why we realized we don't know what we don't know, and the purpose of our recommendations to both the NYPD and to DOC to conduct their internal audits was to learn whether or not there are other instances that we don't know about. I will say that DOI receives 13,000 to 14,000 complaints every year. We have not been receiving the complaints along this in this subject matter, so that's potentially a good thing. But the reason we asked for or recommended the audits was to answer exactly the question that you're getting at. Are there instances that we don't know about? And the audit seemed like the most appropriate way to filter through. However, we didn't want to wait to issue reports until that time, because that would have taken a lot of time, and given what's happening on the streets in all of your districts right now, we felt that getting you the best information we could in the most expeditious period of time that would still be useful to you was the balance that we thought we would strike.
I think that makes a lot of sense. And I guess to put a finer point on that, one thing you just testified to that was very important is we don't know what we don't know. Right. And from what you all revealed, even with the limited instances, showed larger systemic problems, which, for example, a department-wide audit by DOC could address when there's lack of training. So I guess I would put the question a bit differently. Does your report give you any reason to believe that these instances of violations of our sanctuary laws, particularly with respect to DOC, where there was lack of training and lack of an audit, do your findings give you any reason to believe that these were isolated instances?
We conducted a targeted investigation. I mean, I'm not trying to avoid your question anyway. It's a very hard question.
You're a former prosecutor, so I know that you know exactly how to answer the questions and ask them.
I mean, the odds that any inquiry conducted similar to ours would capture every instance, I couldn't come before you and say, I mean, just that's likely. There are very likely other instances that that possibly the agencies don't even know about. I mean, what we were looking at, and a lot of the information we were drawing was from relating to what was in some ways known within the agencies. But there's possibilities that there were other incidents that were happening that have not been captured. I think our goal was to give the agencies as much information as we could and as much guidance up front, notifying them of what we were seeing so they could see where the points of failure within their own agencies were and correct them immediately. So hopefully at this point in time, when I'm speaking before you, that the incidence of any further incidents would be either less or none currently. At the time, but at the time our reports were issued, I could not tell you that we had captured the universe of incidents. But the efforts so far made, particularly by the NYPD, have been really robust to get a handle on this and to make sure that they're as confident as they can be that these incidents are not happening.
Thank you. I'll now turn it over to my co-chair, Councilmember Brooks Powers.
Thank you. Hello, Commissioner. Just a few questions for you. Has DOI evaluated whether there are technological safeguards such as systems access controls or logging that could prevent unauthorized information sharing by the Department of Corrections or NYPD with outside agencies?
The focus of our report was on the personnel element, that human element, using the technology and knowing not to, if you have access to that information in your day-to-day work, to know to whom you can disseminate it and to whom you cannot. We did not look at the technology or the systems themselves.
Has DOI considered recommending periodic compliance audits or spot checks to ensure ongoing adherence to sanctuary laws?
Absolutely. In both of our reports, exactly that type of audit that the chairperson is suggesting was included.
And did DOI identify any systemic vulnerabilities that could allow federal agencies to obtain information indirectly through criminal investigations?
One moment. So the sanctuary city laws as written prohibit the city from directly assisting federal authorities with immigration enforcement. The laws do not regulate the federal government's secondary use of information for another purpose where that information was initially provided to the federal government for a permissible purpose. So there's no control over that downstream use of information or secondary use of that information in both practice or in the laws that exist on the books today.
Oh, thank you for that. That's a big gap that should be looked at. Thank you for that. What safeguards exist to ensure that officers assigned to federal task forces within NYPD and corrections are not inadvertently facilitating civil immigration enforcement?
Yeah, and that's certainly, as you have seen in the report, something that we saw based on a lack of certainty as to what information could be disseminated and to who. There is a much, and I think it's based on the work of the council, the new administration's focus on this issue, and what is being reported in the media. There is a newfound, I think actually an urgency within both agencies to make sure that their frontline staff are fully educated, fully trained on these issues, so as to prevent any further instances. So I think it's largely a training exercise that both agencies are in some degree of a process. I think they're focusing on the most likely. Like the task force officers are typically the first one who would be encountering this. So I think in terms of rolling that out in both agencies, that's where they have both started. But I think they're both committed to training their entire staffs on these issues to prevent the exact type of concerns that the council, that the chair member has.
Thank you. Does DOI stand by the recommendations in its two reports as comprehensive and sufficient for the Department of Corrections and NYPD? Or do you agree with the mayor that additional review is needed to suggest further revisions?
I think based on the investigations we did at the time, our recommendations reflect the reports and the investigations at that moment in time. Obviously, that is September and December, respectively. A lot has happened in the world since then, and the mayor has certainly committed to ensuring every city compliance with this. So I would think, like any other good policy with an ongoing situation, recommendations are up to date given changing circumstances. I never want to say anything is sufficient. I think we can always, certainly as city government, always do better, and should be keep trying to do better and better and maybe set periodic increments where we reconsider but nothing is ever sufficient. We should always be trying to do better. But I think the recommendations we made, we certainly stand by them, and at the time they were the starting point of this conversation.
Thank you for that. I want to pivot to the Fusion Center on Rikers Island. City law bars federal immigration authorities from maintaining an office or quarters on property over which the Department of Corrections exercises jurisdiction for any purpose. However, ICE may still have access to the jail's massive audio surveillance database through a Fusion Center, an intelligence sharing hub conceived and partly funded by the Department of Homeland Security, that the city does not acknowledge. Did your review of the Department of Corrections policies and incidents consider the existence of the Fusion Center?
The Fusion Center was not a subject of our report, no.
Considering in local law 228 of 2017, where it is mandated that no city resources, including but not limited to the use of city property, shall be utilized for immigration enforcement. If the Fusion Center exists, do you believe it would violate the city's sanctuary laws?
I would not be in a position today to give you an opinion on that, and having not examined the present or nature of any Fusion Center on Rikers.
Right, but what I'm saying is, considering that law, local law 228 of 2017, if there was a Fusion Center on Rikers Island, would that be a direct violation of the city's sanctuary law? If it existed.
If a federal facility that was facilitating the improper, well, not even facilitating the improper use. I mean, the answer is probably yes, but without knowing more of the hypothetical, it's very difficult to answer. But if there is a facility that's operating on city property that is operating in violation of current city law, then yes, that would be a violation.
And I think we could agree that that would be a violation of city law, considering that the law says that no city resources, including but not limited to the use of city property, shall be utilized for immigration enforcement. And so if we suspect, and if it does exist, a Fusion Center that is doing immigration enforcement, I would argue that that means that it's in violation.
Yes.
Do you agree?
Yes.
Okay. Thank you for that. Chair?
Thank you, Chair. I'll now turn it over to Councilmember Carr.
Thank you so much, Chair Krishnan. Commissioner, good to see you. Thank you for coming today and discussing your report. I just want to sort of get into a little bit what you were talking about earlier. You talked about the supposed virtues of the sanctuary city policies with respect to people being comfortable coming forward in a law enforcement context as witnesses and perhaps in other scenarios. But surely those sorts of benefits don't apply when we're talking to people who are coming into contact with the criminal justice system from the other end, right? People who are arrested, people who have trials pending and they're in Rikers, or people, many of whom may have actually been convicted in prior proceedings. So what is the harm to the city in cooperating with ICE in those circumstances, in your view?
The current state of city law is that cooperation on matters of criminal immigration is permissible with city agencies. So the NYPD can cooperate with federal agencies on matters of criminal enforcement.
But not immigration civil enforcement, right? That's Correct. What I'm talking about, is that what is the virtue of not engaging with ICE constructively in response to their detainer requests?
That is a matter that was outside of DOI's report. It's not something we studied. It's not a matter that's
Well, you felt comfortable venturing a potential benefit in another portion of your testimony. Why not venture one now? What is the virtue of shielding these individuals from civil immigration enforcement when they've come into contact with the criminal justice system in a way that is not positive? Right? These are individuals that are arrested, they're awaiting trial, some of whom may have been convicted of past offenses. What is the virtue of the city shielding those individuals from federal immigration enforcement, in your view?
Well, I think if you're talking about individuals who are actively within the criminal justice system, who have committed criminal offenses that could potentially lead to deportation, that falls within a widely already recognized area of permissibility with cooperation. If you're talking about simply someone who is, I mean, you're talking about it within the criminal justice process, so that puts it potentially squarely within federal criminal enforcement. That would not be civil enforcement.
Yeah, but the
I'm
reason,
understanding your question.
no, you're not. I'm saying that ICE is seeking detainer requests for people for a civil immigration enforcement matter. These individuals have come into contact with the state criminal justice system, right, or city agencies. So they're not, the federal government's not per se enforcing a criminal matter, but they have an opportunity to engage with our law enforcement entities and take these folks into custody and then engage in immigration enforcement. And those folks can have their day in immigration court as to whether or not they should be removed or not. What is the virtue in the city shielding these people from that eventuality?
That is ultimately a policy discussion for the council. That is a balancing. The council will set and the administration will set the parameters of what city law will be. The council and the city have set forth the laws as they are, and that's the law of the land. Whether certainly we could debate, the virtue of one virtue versus the other. We are looking at city law as it applies, or as the NYPD and the DOC complied with existing city law. We did not look at potential anything relating to what the council, respectfully, what the council member
Yeah,
is.
no, I respect that you're not a policymaker in this particular instance, but you ventured forth a benefit of the process or of the sanctuary city policy in another matter, and you're straining to come up with one now because, frankly, there isn't one. And these folks who come into contact with the criminal justice system should be handed over to ICE. And the legality of this local law that you're giving your report on is being litigated currently. The Department of Justice has sued the city in order to enforce the supremacy clause of the Constitution, rightly, in my view. And so I think that the situation is that New Yorkers are rightly concerned. And again, I'm not talking about the situations that you referenced earlier, where folks maybe going to school or engaging in city services or whatnot. I'm talking about the people who come into contact with the criminal justice system because they've been arrested for crimes. And there's absolutely no good earthly reason why the city of New York should be resisting federal detainer requests in those situations for civil immigration enforcement, right? So that's the point I'm making today, Commissioner, and unfortunately, I agree that you're not going to be the one to give us the answer. The federal courts are going to do that hopefully soon. Thank you, chairs.
Thank you, Councilmember Carr. Before turning over to Councilmember Brewer, just a couple quick questions. Isn't it the law in this city that New York City agencies are not to assist federal immigration enforcement, barring limited circumstances?
Correct.
And isn't your role as the agency to ensure that the law is being followed?
That's correct.
And isn't it also a matter of separation of powers between local and federal government that is the responsibility of the federal government to carry out civil immigration enforcement?
That's correct.
And it is the responsibility of city government to carry out everyday city functions and services, correct?
That's right.
And in those instances where there may be sharing of information between the city and federal government, the sanctuary laws that we in the city have passed years ago define explicitly those limited public safety circumstances, but they do exist, but limited public safety circumstances where such cooperation will be permissible. Isn't that correct under
Yes,
sanctuary laws?
absolutely. There are areas delineated in the law to many ways to provide for the cooperation should it be necessary. Yes, that is in the law that's written.
And isn't it also correct that your report, DOI's report, identified instances where those laws were violated. In other words, where instances outside of those limited public safety circumstances, information was impermissibly shared between city and federal agencies. Isn't that right?
Yes, we saw that that is detailed in the report.
And so isn't it also true that that raises a serious concern and risk that DOI also highlighted, that when the law is not being followed, even with these limited exceptions, there are instances that have occurred where outside of those exceptions, information has been impermissibly shared? Isn't it true that it also raises a concern for DOI in your report that there may be additional instances, there could be additional instances where such information was impermissibly shared outside of those exceptions, and your role is to ensure that that does not happen. Is that correct?
Yes, the recommendations we made relating to the audits were to capture exactly that, to determine whether or not there are any other instances that that can be deterred, that can be identified in the past based on that type of audit. Yes.
Thank you. On that, Chair Brooks Powers also had one more question that she wanted to ask as well.
Commissioner, you also said a structure for an NYPD task force audit is under discussion. It's more than 4 months after your report came out and about a year since most events described in the report. Do you consider that kind of delay the NYPD accepting DOI's recommendation?
Yes, my understanding is that the NYPD has been preparing and coming up with a methodology for doing that work. And I think, like as I testified earlier, I think this work will also dovetail with the new audits that the mayor has ordered happen at all 6 agencies. NYPD will be one of them. So whatever preparatory work they've already done for the audit will be included in the work that the mayor has detailed should be done, I think, under Senior Advisor Mustafi's office.
And at what point do you consider delays a practical rejection, if at all?
I guess it's kind of a you know it when you see it situation. I don't think that's even close to being the case. And a lot of the preparatory work that the NYPD for an NYPD audit had already been underway. Even I think at the time that DOI issued its report. There's an understanding of the work that needs to be done, and I believe it's being done diligently and in good faith. I don't think there's any foot dragging or delays at all. Certainly not that DOI has seen either in any of our conversations with NYPD.
Thank you.
Thank you so much, Chair. Now turn over to Councilmember Brewer.
Thank you. I think 2 things could be true. We can love David Carr and Sanctuary City at the same time. So I just want to point that out.
Agreed.
Question is, first of all, congratulations also on your NYCHA report, which you just issued. Congratulations. With the issue of contracts, now that's not necessarily something that you looked at, but I'm interested, and I think the chair is also, the role of private contracts in all of this, because obviously ICE probably works with companies. I know, for instance, there are ICE rentals in our city. Those are with companies. So I just was wondering, in the investigation, although I didn't see it here, was there any situation where you found contracts, city contracts, ICE contracts, in any way, shape, or form playing a role either through the audits, your investigation, and so on?
There was not, no.
Okay. Second question is, I think maybe you discussed this a little bit. We're talking about correction and NYPD. Any other agencies that have come to light in this investigation working with ICE?
No, these were very tailored to those two agencies, both based on the report, the referral from your office
Yep.
and from the former speaker and from a DOC complaint. We did not look at any other agencies.
Okay. And so I know we talked about the audits quite a bit. So but with both agencies, again, we don't know the timeline, that's what you said, but what do you hope to get out of the audits? What do you think they should be included, et cetera?
I mean, I think both audits were intended to be a review, a retrospective review, to see if there's any evidence of what the chairperson had alluded to earlier. Could there be other instances that simply no one has uncovered yet? I think one of the ways that DOI thought would be an effective approach to that would be to look at email, for instance, in the NYPD context, within the communications between task force members, to see if there were any requests being made or anyone in the NYPD had received either an email request or referenced in email requests from the federal government that they were either concerned about or that were improper. I think that was a kind of a first step. That would be a very discernible way of approaching, that type of investigation, whether or not there's any email traffic relating to investigations.
And corrections, same thing, or
Corrections,
different, same idea?
the same thing.
idea.
I think the corrections audit, we didn't necessarily mandate how the audit was to be affected. I think the NYPD focused on the email of task force officers as its first phase. I don't believe the DOC has concluded exactly what the focus of the audit will be, and I'm not quite sure what the new audit as mandated by the mayor, exactly how that's being structured, whether that's similar or broader, narrower. We hope to learn more about that once that begins to get up and running, and hopefully DOI can be an effective partner.
So when I'm on the street, the officers, PD I'm mostly with, they know for sure, do not coordinate with ICE. I got that. These federal task forces have existed for a long time because you have to collaborate, coordinate, blah, blah, blah. So how do they operate? I mean, this is a different time. How do they operate now? How are they, as far as you know, similarly to how they in the past? Obviously, there's a different president, for lack of a better word, who is conducting this, I consider them raids. Do they operate differently to the best of your knowledge? Similarly, I mean, when you're talking to your friend who's an ICE employee and you're a PD, you have to keep your distance, but you still have to coordinate, I guess, for safety of the country. So I don't know, how do you think, is it different? Does it work similarly? Do you have any recommendations how these task forces should work? I know it's not necessarily PD to do this, but I just didn't know if you had any suggestions.
Well, I mean, obviously not part of the reports that DOI issued.
Right.
My understanding generally is that the task forces that, as you said, have been in place, Joint Terrorism Task Force, Joint Robbery
Correct.
Task Force, have been around forever.
Yep.
The hope is that the purpose that is in the name of the task force, or HSI's Violent Crime Task Force, that they are true to the name of the task force and don't stray from that mission to keep the country safe from all sorts of different topics that they were established for. I think the concern is, are they doing that? But the structure is the same, and I can say that the NYPD has put in place safeguards to ensure that their officers and detectives are not being asked to engage in practices that would be in violation of any sanctuary city law, and those safeguards were both very intelligently designed and seem to be implemented well.
Okay, just one last question. Ongoing, because this is obviously not ending in terms of the concern, so I assume the audits will bring up whatever they bring up, but do you have some suggestions as to ongoing? Maybe it's the mayor's executive order. What is it that can make sure that what you provided, what you found, gets A, addressed, but B, doesn't happen again in the future? Is it more audits? Is it more in my opinion, people don't have a clue what sanctuary city means. That's relevant. But any suggestions along those lines? How do we maintain the recommendations that you made and others that probably will maybe discovered in the audits?
I think we'll know more about that after the results of the audits. As in my response to the chairperson, we don't know what we don't know. Hopefully, the audits will fill in any gaps in our collective knowledge about what is happening right now, and I think that will be depending on what is uncovered, if anything, in the audits. I think will give us a better sense of the intensity or severity of the problem, and whether or not if we see a problem persisting, and then since DOI's reports have been issued, the agency's taking corrective action. If we kind of see some change in practice or change in frequency, I mean, I'm kind of speculating,
right.
But I think we'll know more once we see the audits and can see if we can see the patterns going in the right direction. I think that would be a good sign.
Okay. I mean, one of the issues is that they lie. I mean, the situation at Columbia with lying about a child in the dorm was challenging. So, I mean, I don't, if the cops are told X is a child there, and it could be something that they need to be involved in because it is relevant to them, but you're getting a false information from ICE, it makes it hard to blame the cops for that. But so that's an example of just the worst of the worst. Hopefully, that doesn't happen all the time.
Thank you. I'd like to acknowledge that we've also been joined by Councilmember Narcisse, and next we have Councilmember Zhuang.
Thank you, Chair. Thank you, Commissioner, to be here. I have a question. Probably a lot of people in the public are curious about this situation also. The Cornell Street raid last year in November, NYPD and ICE showed up in the same time. And a lot of reporters, actually journalists, confirmed to my team that they got tipped off by NYPD about the Cornell Street raid. Is that any coordination between NYPD and the ICE in that situation? Did you guys do any investigation about that situation?
That was not the subject of our investigation. We did not look into that incident.
Okay, that's my question.
Thank you, Councilmember Zhuang.
Thank you.
Sorry, did you have more? No. Thank you. And we're joined by Councilmember Narcisse, which is probably already said. I just have a few more questions, then we turn it over to Department of Corrections for their testimony. Councilmember Brewer and Chair Brooks Powers also hit this point too, but Local Law 228 of 2017 prohibits the use of city property for immigration enforcement. And there are concerning instances where that might be happening or is happening. The Hudson River Park Trust, this has been reported in the news too, operates on city-owned land. Has the DOI considered investigating whether their contracts allowing ICE use of the piers violates the spirit or the letter of the city's sanctuary protections?
We are aware of that situation, and it is something that if DOI has the jurisdiction to review, we will do so. We are aware of it, and we're considering what our proper role in that would be.
Thank you. And I understand that the Hudson River Park Trust is a state city authority, but I do think the city's piers are city resources and land, and that would be something I would hope the DOI would be considering. And I should also add that we are hearing my legislation soon in the Immigration Committee about prohibiting the city from contracting with ICE because there are clearly gaps that are coming up that we're seeing very clearly need to be closed, especially at this moment. I wanted to go back to the joint task forces subject, and I bring that up because one thing that became clear from the DOI reports too is, and especially now, the way in which there are certainly, city, federal task forces around criminal enforcement, but there's a real concern that those task forces, as we saw in these instances too, can bleed into impermissible information sharing around immigration enforcement. Instances where, for example, individuals were turned over impermissibly after they pled to misdemeanors, even though they were originally charged, and they were not pleading to or convicted of any of the serious felonies or otherwise that would qualify for information sharing. So there's a real question of how to ensure that criminal enforcement and cooperation there does not turn into something that it should not be turning into. One question, and we've reviewed, at length, DOC and what needs to happen there. But with NYPD task forces, do you all have a sense of how many NYPD officers are currently assigned to federal task forces that involve agencies that also have immigration enforcement authority?
I don't have that number. That is certainly something we could get back to the council with, or if you refer to the NYPD as well.
If you do have that information, it'd be helpful, otherwise you can track it from NYPD as well. And do you all know, has NYPD conducted any internal reviews following your report about task force assignment, the risk assessment there, and what safeguards to put in place so there is no inadvertent facilitation of civil immigration enforcement?
Yes, certainly the NYPD could give you a better understanding of with exactly what they're doing. But our understanding is that the NYPD has put in a series of controls, elevating requests for information from the NYPD, elevating it from the task force officer up to a supervisor. So before any information is shared between a potentially federal immigration authority and the NYPD, there is a conversation between a NYPD supervisor with the supervisor from the federal authority, asking, as far as we can tell, the right questions, to kind of, as opposed to task force officer and task force officer from different agencies. That is both, the NYPD has proactively elevated that up to a supervisory level, which is a very intelligent and well considered risk management measures. Obviously, they're trying to manage the risk and reduce the risk, but elevating it up to that management level seems like a seemingly very intelligent control to put in place.
Mm-hmm. And on the topic of agency reporting requirements, is it your interpretation that Local Law 228 of 2017, that NYPD, DOC, DOP are required to report the same information as every other city agency on an annual basis, above and beyond the reporting required in the detainer laws? Would you agree that they're all subject to the same reporting requirements?
So my understanding is that as the law is written, there is no explicit exception for any of those agencies. So they are without such an exception. They are the law is applicable to them as any other agency. There doesn't seem to be anything special about that.
Have those agencies agreed with this interpretation or sent you notice they agree as they've adopted the policy and procedure recommendations?
I don't believe we've had those conversations. We'd have to refer that back to the agencies.
Sure. Well, that concludes our questioning for you. Thank you, Commissioner. Oh, sorry. Councilmember Narcisse has questions. Thank you. Almost done.
Very, very quickly. I'm not going to take you long. Knowing the city of New York, how complex that we are, right? We want our community to be safe. We want the immigrants to be safe, and we need fair treatment. How your agency balance those priorities in practice?
I mean, as the city's inspector general, DOI provides oversight over the agencies on a variety of different matters. We take referrals and very seriously, whether they're complaints from from communities in our outreach efforts, or or through the council as your constituents raise issues to you. But I think the way we manage our oversight responsibilities across the city, across all the agencies, we try to find that proper role of working with the agencies to make their service delivery better, to examine how they're engaging with their communities, and to make sure that everything is done in a professional, fair way that avoids risks of corruption and fraud and abuse. So we are certainly supportive of all the city agencies, and at the same time, we provide meaningful oversight. If we see any issues beginning to brew, we try to provide the kind of guidance and to the city agencies to get them through our policy and procedure recommendations to get them effectively working for their constituents. I don't know if that answers your.
Sort of. I know that my colleague Gail Brewer probably talk about the agency. How many, do you have enough staff to actually do the work? As a matter of that, one of the biggest supporters you have in here, always talking about the importance of giving you the support that you need, to do your job. So, Sanctuary City always are very confusing things for a lot of people. From your perspective, can you describe it from your understanding, what the specific that you do?
What we do
No, for Sanctuary City.
Oh, so sure. So
sorry, I apologize.
When we refer to sanctuary cities, we're talking about a series of city council laws and mayoral orders that govern the manner in which city agencies are able to interact with federal immigration authorities and limit the city's ability to participate in any activities that would be considered prohibited activities relating to civil immigration enforcement. It's a body of laws that govern this entire area, and we're periodically see new laws added and new mayoral executive orders added, but it is that body of law that safeguards communities and allows people whose immigration status may be either in flux or otherwise from enjoying the life here in New York that we all want to enjoy without the fear of an interaction with a necessary city agency causing them to be impacted with federal immigration enforcement.
That's where things collides for us right now. So I'll yield back to my chair. Thank you, Chair.
Thank you so much, Councilman Narcisse. Thank you, Commissioner. Appreciate all your great work and your testimony today, too.
Thank you. I appreciate it.
Thank you. Now we'll be calling up representatives from the Department of Corrections to testify, and I'd ask the committee counsel to swear them in once they are seated.
Thank you, Chair Krishnan. We will now hear testimony from the New York City Department of Correction, specifically James Conroy.
We'll see the highlights.
Yeah, absolutely, yes. If you want to see this.
Before we begin, I will administer the affirmation. Panelists, please raise your right hand. Oh. Mr. Conroy, do you affirm to tell the whole truth, and nothing but the truth before this committee, and to respond honestly to council member questions?
I do.
Thank you. You may begin when ready.
Good morning, Chair Brooks Powers and Chair Krishnan, and members of the Committees on Criminal Justice and Oversight and Investigations. My name is James Conroy, and I'm the Deputy Commissioner of Legal Matters and General Counsel for the New York City Department of Correction. I appreciate the opportunity to testify today regarding the department's policies governing interactions with federal immigration authorities, the findings of the recent Department of Investigation report concerning DOC interactions with federal immigration authorities, and the steps the department has taken in response to DOI's findings and recommendations. The department has largely accepted DOI's recommendations and will detail how they have been implemented to date to safeguard against an incident of this nature occurring again. This issue is one of importance to Commissioner Richards, and our goal today is to be clear and transparent around our process and the steps we have and are taking to address this matter. The department's long-standing policies regarding interactions with federal immigration officials are grounded in New York City sanctuary city laws. In accordance with these laws, the department does not engage in immigration enforcement and does not subject its officers or employees to the direction of federal immigration enforcement authorities. As a matter of policy, the department does not honor immigration and customs enforcement detainers absent a judicial warrant. In accordance with local law, if the department receives a detainer from ICE, in some circumstances, ICE will be notified of an individual's discharge, but only if the individual in custody has a qualifying conviction as defined in local laws, meaning a conviction for a violent or otherwise serious crime within the past 5 years, or is identified as a possible match on a federal terrorist screening database. The request also must be supported by documentation establishing probable cause that the individual is subject to removal proceedings. This notification can be made in advance of or when the discharge process begins. Importantly, the department will not detain an individual beyond the time that the individual is authorized to be released from custody. Perhaps most significantly, if any of the required criteria are not met, meaning no qualifying conviction or no match in a terrorist screening database, DOC will not communicate with ICE about the individual in question. The department's public reporting for the fiscal year reflects that cooperation under these narrow circumstances is infrequent relative to the number of detainers that are lodged. Between July 2024 and June 2025, federal immigration authorities lodged 595 detainers and 19 individuals were transferred to federal authorities. This may be better illustrated through our calendar year statistics, however. In calendar year 2024, the department recorded 403 detainer requests. Of those, there were 18 transfers. In the calendar year 2025, the department recorded 895 detainer requests, and of those, 25 individuals were transferred. In September 2025, DOI issued a report that examined conduct by an investigator in the Correction Intelligence Bureau, who was assigned to a joint federal task force. DOI found that in 2 instances, the investigator inadvertently provided information about individuals in custody to federal immigration authorities in furtherance of civil immigration enforcement, despite that no detainer meeting the statutory criteria had been presented in connection with the individual. DOI further concluded that this assistance violated city law and DOC policy. In its findings, DOI found that the investigator did not understand that the assistance was being used for civil immigration enforcement rather than a federal criminal investigation, and that the department had not provided sufficient training, guidance, or oversight to ensure that staff, particularly those assigned to federal task forces, could reliably distinguish between permissible coordination and impermissible civil immigration assistance. While DOI found that the investigator did not intend to violate the law and did not appreciate that the assistance was being used for civil immigration purposes, the fact remains that city resources were used in a manner that is inconsistent with the local laws. The conduct described in the report, although inadvertent, should not have happened. The sanctuary city laws are clear, and the department is bound and complies with them. We agree that clear guidance and robust training are necessary to ensure that these types of incidents do not occur again in the future. DOI issued several recommendations to prevent this type of incident from recurring. Recommendations include that DOC provide updated guidance and in-person training on applicable city law and department policy, clarify and streamline internal procedures regarding communication with federal partners, and assess whether any other instances of unauthorized assistance occurred, among other things. The department has accepted the core recommendation as it has already taken concrete steps to implement them. The first 3 recommendations made within the report relate to providing updated guidance and training on city law and policies, and specific guidance on how to respond to requests from law enforcement partners and immigration-related requests. In response to those recommendations, the department's legal division conducted in-person training for relevant units that are most likely to have contact with federal law enforcement partners. Training was conducted in April and May of 2025. The training reiterated obligations under local law and DOC policy, as well as proper communication protocols with federal immigration authorities. Additionally, since that time, the legal division has provided a training on this topic at each of the department's leadership training courses for newly promoted captains and assistant deputy wardens. DOC is continuing to explore opportunities to expand training to additional personnel. In addition to the trainings, an agency-wide teletype was issued, which was read to personnel over 21 consecutive roll calls, reiterating the internal policies regarding interactions with federal immigration authorities remain full and effective and must be strictly followed, and that any immigration-related requests must immediately be referred to the DOC ICE unit and the DOC legal division. DOI also recommended that senior DOC officials coordinate with senior federal agency officials about limitations set forth in the city laws. DOC leadership has already met with senior officials and other agency liaisons at federal agencies with whom its staff regularly collaborate. DOC will continue to engage federal agency partners on these issues and reiterate its commitment to ensure practices comply with all applicable laws and policy. As recommended, DOC also reported previously unknown interactions with appropriate city partners for public reporting purposes. Finally, DOI recommended certain policy changes as well as an agency-wide audit. While DOC has partially accepted these recommendations at the time of the report's publication, the department is currently working to implement Mayoral Executive Order 13, which requires an audit and review of all agency policies and practices as it relates to interactions with federal immigration authorities. The work is underway, and the outcome of this collaborative assessment will guide future policy and training, which will be made publicly available on the department's website. The Department of Correction is committed to the goals of upholding public safety and protecting the safety and security of all individuals in custody, as well as those working within the city jails. To be clear, those goals do not include enforcement of immigration laws or in any way engaging in conduct that is inconsistent with this city's sanctuary city laws. We are grateful that these incidents were reported to help us ensure that we are addressing any gaps in the implementation of our policies, and we remain committed to the implementation of these laws and open to hearing from families, lawyers, elected officials, and others about issues and challenges as they arise. Thank you. I'm available to take questions. Thank you.
Thank you so much, Deputy Commissioner, for your testimony and for appearing before us today. I have a few questions, and I'm going to turn over to my co-chair, and then I'll come back and ask more after my colleagues ask questions, too. Sure. I appreciate your testimony today because I think we are at a very crucial and concerning moment now. One of the themes that we keep hearing from advocates, and we're seeing in the council, is that this is not a new issue with DOC as well. If there have been instances in the past, in the recent past, those reported, those likely not reported too. And I think, you know, what is new now is a mayoral administration and leadership at DOC that is committed and shares our vision of addressing these issues. So we have this conflict here between what's happened in the past repeatedly without seeing change despite our hearings, but new leadership that shares our vision. And what I'd like to do in a constructive way is see how we can once and for all address these issues so that what happened under the prior mayoral administration, we break from that past and it does not happen again, but we make concrete efforts to do so. So on that note, can you just restate again, you did so in your testimony, but with new leadership, with Commissioner Richards there, with Mayor Mamdani and the new executive order as well, can you just restate how has the new leadership at DOC changed the agency's perspective about sanctuary law compliance?
Thank you. You know, as you know, Commissioner Richards is only in in place for a few weeks now. And as you also know, the Department of Correction has a lot of things that we have on our plate and have to address. This is one of them. Obviously, with Executive Order number 13, it required us, and we have already begun to engage with City Hall and the Interagency Response Committee, if I misstated the name of that, but with the committee, to begin the steps to enter into this audit and figure out how to do that more robustly. Commissioner Richard is clear that his vested interest in this agency in collaboration with our city partners is in accountability and transparency, and that is his mission statement, to everyone in the department and to, city partners and including the council. So that is what we are going to be doing and working towards. And again, we've already begun the work of conducting this audit to be in compliance not only with the emergency order, Executive Order 13, but also just to look at our current policies and practices as both the Department of Correction and City Hall will be doing to see how it informs future adjustments.
And, I'm glad to hear that, because I do think, as we saw, and you probably heard with that prior questioning with DOI as well, these instances are likely not, we know, not isolated instances, because there was a pervasive lack of training within DOC, and officers that are part of these larger efforts that are communicating unbeknownst to supervisors, in violation of the law. They may not know the law themselves. It's just what we see from all of the DOI investigation, which was not that long ago, it was just in the fall, was that these are systemic issues within the agency. And so, and again, that DOI report came out in September of 2025. So, DOC is a very big agency, knowing government well. These things take time, so I suspect that these issues are still present as they were back in September, and they will be now too for you all to address. My question is, given the recent executive order, is it your testimony today that DOC will accept in full recommendation number 6, requiring the agency from DOI to conduct a department-wide audit? Because one thing that really stood out to me, it was very concerning, was the prior administration's leadership at DOC refusing to accept that audit, and it seems to me that is the crux of what we're getting at here. So is it your testimony today that DOC, under this new administration, will accept recommendation number 6 in conducting a department-wide audit?
If I may just first, Chair, clarify our acceptance or position on that. The issue with the acceptance of that specific recommendation of a department-wide audit was not that we are unwilling. What it really comes down to is a practicality of how our agency operates and functions. The reality for us is that agency-wide, the vast, vast majority of our officers, up until very recently, did not even have an email address, a department email address. When they are on post and on staff, they do not have access to computers or phones. So when we contemplated how and what we can do to do a department-wide audit, we thought most practically it would be the most productive also to focus on the areas in which there is and we know to be this interaction. The reality is, in our facilities, federal officials from any agency do not have direct access to just come onto Rikers Island and go to a facility, so that you'd have, direct interactions with the line officers, and there's a lot of different protocols and approvals that have to allow anyone to come onto Rikers Island. So our not full acceptance of that is not, again, as an unwillingness. It was more, we don't want to overpromise and underperform in that area. So that's the nature of our response to that. Nonetheless, whatever we come up with our the committee as to how to conduct an agency-wide audit, if it can be done, or what the recommendations are on how to more broadly encompass or review, we would accept that. And I'm hopeful that once we get to that point, we'll raise that, as the Commissioner of DOI indicated, that we have a good working relationship and communication with them. So, I would be hopeful that we would be moved into full acceptance and implementation of that. But again, very long-winded way of saying yes, but I did want to clarify our position on the previous partial acceptance.
Understood, and thank you for the clarification. I think the challenging thing, and we'll go into it, more in a bit too, is that despite that perspective from DOC, there are always in the details of it, the cracks, the gaps, and things that happen. So when the agency doesn't commit to it, especially in a moment where you had a prior administration that was overtly wanting to cooperate with the Trump administration, and for reasons we don't, this is not germane to this hearing, but I've made very clear that part of it had to do with the corruption indictment and the plea and the dropping of the indictment. All of those things are extraordinarily grave concerns, and mixed up with that was Mayor Adams overtly, publicly wanting that cooperation, wanting to have ICE on Rikers Island in contravention of our very clear, well-settled law. So not accepting that requirement in that context signaled a lot more that I would hope is going to change now. And it would be our expectation that both in compliance with the executive order, that DOC is also communicating with DOI, that we can get to a place where you all are fully accepting that recommendation, because that is, I think, necessary given the systemic issues we've seen here. My other question was, has the appointment of a federal receiver changed DOC sanctuary law compliance practices or responses to DOI's recommendation? How do you see that interacting?
The remediation manager versus receiver, that's the formal name. Their oversight into the Department of Correction is very limited and focused specifically on 18 provisions of the Nunez consent decree and remedial orders that the judge found us to be in violation of, in contempt of. So none of those remedial orders or the provisions, contempt provisions, are related to any type of immigration enforcement or even partnerships with federal agencies. It's very squarely on internal investigations and the use of force policy. So my answer is no, because again, the limited purview over which the remediation manager will have authority.
Sure. Thank you. I do have more questions as well, but I'm going to turn it over to our co-chair first, Councilmember Brooks Powers, for her questions.
Thank you. Thank you for the testimony. In response to DOI's 6th recommendation, you state that an agency-wide audit is impractical, but would consider targeted reviews of emails. Since you have declined a full audit, how can the council, the public, and even DOC leadership itself be confident that more violations haven't already occurred?
Thank you. As I stated earlier, the focus of the audits and the targeted audits and the training, to be quite honestly, that we've initially rolled out is on those personnel that we have that would really have direct interaction or even the risk of interaction with any federal officials, particularly those in immigration enforcement. So it's not, again, I do want to reiterate that it's not a declination of the desire to do a full audit. It really becomes the practicality of it. And, how do we accomplish that? We're going to do, our plan is to do much more robust training that will eventually capture all DOC employees, even in those areas where it's complicated. So, we do think that the limited look that we did into the specified agencies and what DOI did for us identified those, as we said earlier, gaps or instances. And we don't know that necessarily expanding out to, I guess, the only practical way would be to go to each officer and say, have you had an interaction? Have you it's just impractical. So it really does, I don't want to characterize it as a declination to conduct this. It just is getting to that point of how we do it most effectively to capture what everyone, including ourselves, is looking for.
What resources would you need to conduct the suggested agency-wide review?
It's hard to say right now, and I would really like to have further conversations with the committee and City Hall before we do that. I don't know that any are necessary really right now, so we could look into that. But again, I would reiterate that audits are very often done by email searches and other access to computers, most of which our uniformed staff do not have or have only received recently.
So you had, just going back to something you said about like everyone not having an email, which is kind of strange for an agency. But how do correction officers communicate with each other typically?
Verbally.
Why has the department not been able to provide email addresses to everyone?
Well, we have now. I mean, I think it was just a matter of, again, in the nature of our work and what where limitations are regarding electronic devices and otherwise, I can't speak. This kind of precedes my tenure in the department as to why it historically had not been done. But the idea is that everyone gets an email address, but if you have no mechanism to access it, I don't want to say what's the purpose. We've now since given it so we could do the more effectively roll out DCAS trainings, like the online trainings and informational kind of flyers or informational emails. But again, still at the same time that the officers are not assigned, unlike NYPD, everyone is not assigned a department phone and doesn't have access. There's not an individualized terminal and computer to which they could access anything. It's really a physical, hands-on, in the housing area job. So that's the reason. But
So if officers are communicating through phone or in person, as you stated, does that mean that those conversations would not have been captured in the audit?
well, but I think we're saying that they're not emailing and phoning. So right.
Right, so it's not captured
I mean,
in the audit.
we can't do we can't do a practical, quick, easy assessment into those communications because there is no electronic capturing of that. You can't look at the phone records to see who communicated with whom because there are none. Same thing, emails. There's no assessment on a department-wide basis. Again, I don't want to imply that we're not doing that for the people who have that and who have these interactions, but on a wide-scale method, it's just impossible. So yes, I'm sorry.
I mean, I think that's a bit alarming just in itself because that means that there's a lot of information that when you think about the need for transparency from a legislative perspective and from the public in terms of advocates, there's a glaring vacuum that exists right now where we're not able to do a full audit if there's no way to track or trace or report this stuff.
I'm sorry. I would add that even in the DOI investigation, when these violations were found, they were through email. So by proxy, if the officers do not have email and can engage in email communications with anyone outside of DOC, that prevents that inadvertent, unintentional, or even purposeful communication outside. So, I mean, I appreciate what you're saying about accountability and looking into it, but if the ability to make that communication was not there and we don't have people in the facilities without prior authorization, then, we're confident that there is not this communication on that line level officer kind of, rank and structure.
Is body cam footage captured in the audit?
In the audit relating to this, no, because an interaction of that nature would not be under our current policy, a mandated activation. Nonetheless, I mean, we do have, a very robust camera system department-wide, but we've not found an instance that would warrant, such a wide-scale review, again, because that's covering our facilities, and we don't allow these federal partnerships to come into our facilities without some collaboration with one of our other investigative units.
And just for point of clarification, are you saying now that all DOC employees have access to an email account?
I believe that to be so. I don't want to make that affirmative representation. I know we were rolling out to all members, but yes, the intention is for all members of DOC to have an email address. I just don't know if we're at full implementation, but we're largely.
What's the timeline for full implementation?
I think it should be done, but I don't want to make that, we're under oath, so I don't want to make the representation until we still have, 10% to go. But I believe that to be the case. We should be imminent if it's not done already.
Okay. And have you conducted any email audits prior to the report to determine whether your staff is complying with relevant sanctuary city laws, or, was this not like a thing?
We did do an email search relating to, there was federal testimony, I think that was supposed to be given by the previous administration. And in furtherance of that, because it was an inquiry from Congress, we did do an email audit. We did not find anything of this nature, but it preceded the report that we had.
Have you made a final decision on recommendation 4 where you said you would, quote unquote, consider mandating Department of Corrections, ICE unit, or legal division to ask other units if they have received civil immigration requests?
We've not made a decision, and that's going to be part of the recommendations, hopefully from the, the committee's recommendations during that part of the audit. I will say this much, however, we actually, the consideration for that is not in its concept or the benefit to it. It's actually if ICE unit or legal are the ones to be making those inquiries. We have other units that might be better positioned and considered to do that, but nonetheless, we still have to get to a policy place where that's implemented. I think we will be there. Again, I don't think that certainly will not be a rejection. We'll get to a point where there's some level of acceptance on that. It's just a matter of how we do it and who does it.
Recommendation 7 asks you to, quote unquote, report any previously unknown or unreported civil immigration enforcement related requests to the Mayor's Office of Immigrant Affairs. But DOI found in finding number 9 that the federal requests relating to Conception and Villanueva were in fact not reported to Moya. How will you ensure that the department complies with reporting requirements going forward?
So the timing of these two incidents was a little awkward because we did have some communication engaged in the training and the reporting, and I forget exactly when our reporting obligations and the communication with Moya, we do that on a quarterly basis? On a quarterly basis. We did recently call Moya to make sure that we had made that notification, and they reminded us that we had had conversations about this when the report was released publicly, but at the time, DOI concluded their report. We had not had, I don't know if the quarter had ended. So nonetheless, we are continually, and we always do this when we have this quarterly reporting, we do inquire with those units that I have identified as the most primary and likely to be in interaction with any federal immigration authorities. And we do inquire on these targeted kind of inquiries to ensure that anything that we've missed in the other reporting is captured.
And is any specific unit or senior official responsible for overseeing compliance with sanctuary laws and DOI recommendations?
That's me, yeah. The legal division, the general office of the general counsel. So again, all immigration-related inquiries, go through and should go through my office, and we are the primary responders and communicators with DOI.
Perfect. Thank you, Chair. Back to you.
Thank you, Chair. Just a few more questions from my end before going to another colleague. I want to go back to the issue of emails, and I do understand the circumstances of the job and how the considerations are different. But the fact of the matter is, we're talking about communications and communications with ICE that when there were emails, because I know the DOI, as we heard before in testimony, they were reviewing emails and they found direct communication between DOC employees and ICE that were impermissible and violated the law. And that was just in emails, but if many of the employees don't have emails, it raises the real concern of what communication is happening that is not checked or ensure that is not violating sanctuary law. So my first question is just how many DOC employees actually have email access?
Again, as I represented, I think it's everyone now. So I forget what our total head count is. It's I think we're 5,800 officers, another 1,600 civilians. My impression is right now, I believe everyone to have access to email, but again, that's only within 2025.
Right, got it. Okay, I think, so there's email access, but there's also the question of how are employees communicating with ICE? Which employees are communicating with ICE and how are they doing so? Is it by email? Is it by phone?
Yeah. So most of the circumstances, the vast majority of circumstances in any communication is occurring from the DOC ICE unit, which is a subunit of our custody management division. And it's in relation to the receipt of detainers and the anticipated release date of anyone who has or may have a qualified conviction or meets the criteria under 9-131. So that is an email communication.
Because my concern, and have you all seen this within the DOC as well or reviewed it, is what mechanism is there to track any phone calls between DOC employees and ICE? We saw some instances over email, and because there was a written record And that was why a written record was important, was, the DOI was able to identify these flagrant violations happening. But if there are phone calls that are happening, what mechanism does DOC have in place to ensure that there are not impermissible phone calls happening between DOC employees and ICE agents? And obviously we're talking about an agency that does record phone calls between those who are incarcerated and otherwise. So what can we do here to ensure that there are not those impermissible phone calls happening?
I think we do have the ability to look at phone numbers. We don't record employee phone calls. We would have the opportunity to look, and that might be part of what we perceive as a good next step in the audit process when we engage with the city and the committee on this. But again, I would say this: the answer to the issue that you're raising is primarily, and I think should be driven by training and robust training as to the limitation obligations with respect to the city laws and our policy. That's where we had gaps initially. I've really undertaken this mission to change that, in a lot of ways, and again, to figure out how to get this training out robustly. So that's the first thing, is we need to have the staff in its entirety understand what the limitations and obligations are under the sanctuary city laws. Nonetheless, I do think we can do that, a look into the phone numbers and otherwise, but, we're still talking about a very large agency. So we have to look and be very measured and targeted how we look at that. I don't think it's necessarily an easy answer, but again, we are more than willing, and we'll work with, the Interagency Response Committee to figure out if that's a prudent measure to do, or if we could expand on that.
I think that's going to be an essential step. There's no question that training is going to be very important going forward. But on the other side of it is just the accountability measures in place too. We can come back to this in more detail in a little bit, but one of the instances here, as you well know, Deputy Commissioner, was an employee that was literally coordinating with ICE when the bus left Rikers Island, when it dropped off the individual on the other side on Hazen. And, there's so much unmonitored or communication that was happening in that instance, but those were serious legal violations of a regime we put in place. I do think it's going to be critical that DOC also look at what to do, because it's in those everyday instances that these flagrant violations are happening. And understanding an agency this big too, there has to be ways to ensure that employees, if they get the training, that's important, but they may forget that training, or, it may happen they're not aware of it, or whatever it may be. In that moment, there are these real-time instances happening that, it's going to be crucial that the agency look at much more carefully now than under the last administration.
And we agree with that. We do agree with that. But I would say, and I don't in any way intend to mitigate the instance itself, because it is a violation of the local laws. But, what really happened there was what even DOI classified as an inadvertent cooperation. These communications in approved type of ways, in a criminal investigation or intelligence gathering, would have been fine. But what happened here is, because of what was classified, and rightly classified, as a lack of training for those officers and guidance, there was not an awareness of what might have been happening. And that's what I think primarily we need to correct, and what my intention is to correct with training. So that's a starting point. So I do think that you're not wrong in identifying those areas where there are, but in this instance, I firmly believe, and I believe DOI believes, that if there was the appropriate training and guidance, that might have been a trigger for that officer to more communicate with the general counsel's office or someone else in the agency.
Right, and I would also just add that there's the known knowns, right, where there's inadvertent communication and training can help, but there are also the known unknowns too, which is we're seeing now, as I highlighted before too, this federal government is resorting to any means possible to test in any way possible at any cost the boundaries of our sanctuary laws. In taking advantage of the fact that there are these criminal task forces and trying to slide into the criminal way, immigration issues, even if when they clearly fall outside of the criminal public safety exceptions in the laws. So that just raises the burden now of not just the inadvertent instances, but also a federal government that may deliberately has shown deliberately will do what they can to try to undermine and erode our laws.
I do want to represent one thing to the council, so that we're talking about federal task forces and otherwise, and I know that NYPD has a robust amount of those. Right now, actively, we only have 3 officers in our agency assigned to federal task forces. 2 of them are assigned to the ATF, or with the ATF, and 1 is assigned to the U.S. Marshal's Office. So we don't actively have any officers with HSI or any other agencies. We are considering other ones, such as the Postal Service and things like that. So yeah, you're right that we have to make sure that the training and the information and the oversight is robust, but it's not necessarily a pervasive assignment throughout the island. It is very limited as it exists right now.
And what have been the conversations with DOC leadership about specialized training for those individuals who are part of those federal task forces? Because that's a big concern, too.
Yeah, I did that training myself. It was developed based off of a prior training that had been in existence, which I believe was built with MOI's cooperation. I added to it, and I could represent to you that it is unequivocal as to what the obligations are, and I stress that even to the point that I say, if you're uncertain as to what the interaction is or the question is, ask legal. If you're really certain about what the interaction is or the question is, ask legal. I really want the onus to be on me and my attorneys that work there to ensure that we're protecting everyone here, the individuals in custody as well as the officers and everyone else in the city, to make sure that that's adequately.
Another question, shifting gears a bit too. In December, the Department of Corrections had failed to testify at the request of the immigration hearing following the release of these DOI reports. Now, I understand now that we are in a different administration, and so I have 2 questions. One is, has the DOC attended to testify in person regarding immigration in the past 6 months, and will that policy change now going forward?
I'm sorry, could you repeat the question? Yeah,
Sure.
I apologize.
In December, following the DOI report came out in September. In December, there was a hearing by the Immigration Committee. And It's my understanding that the Immigration Committee had requested DOI's presence to testify, and DOI did not show up. Has DOC attended any immigration hearing in the last 6 months and testified? And what will be the department's position going forward should they be asked to testify at an immigration hearing?
Yeah, no, we did not appear then, and we have not testified within the last 6 months. But I mean, to answer your question, we're present now. So it is our intention to appear. Obviously that's in collaboration and communication with the mayor's office, but nonetheless, we're present and ready to answer questions.
And that would hold true for any immigration committee hearings as well.
I have no reason to believe otherwise.
Sure, because I do think that will be an important way to have these conversations and ensure that the compliance is happening too, on an ongoing basis as well. So at the February 15, 2023 oversight hearing on the New York City detainer laws, DOC testified that ICE had never presented the department with a judicial warrant. Is that still the case? And if it's not the case, how many judicial warrants has DOC been presented with in the last year?
I believe that to still be the case. I have not, in my experience in working in this agency, seen a judicial warrant associated with a civil immigration detainer. I have seen, I'm sorry, we have had criminal arrest warrants, but they're distinct. That's not what's contemplated in the law. That's separate. And that was only 2 or 3 times. But judicial warrants associated with a detainer, we've not seen.
So my question is then, how do we ensure compliance? Because part of the sanctuary laws requires, in the limited instances where one of the convictions that qualifies for honoring a detainer request, it does require the presentation of a judicial warrant. And my understanding from legal services organizations and otherwise is that sometimes ICE will come to Rikers to take custody of someone because they have a qualifying conviction based on a request of notification, but without presenting a judicial warrant. Is that happening, 1? And 2, given the serious requirement in the law of a judicial warrant, even for those qualifying convictions, what will DOC do going forward to ensure that ICE is only presenting that DOC is only honoring a detainer request when a judicial warrant is presented?
So the answer to your question is, well, let me go back. It's a long-winded answer probably. Our long-standing policy does not rely on the first part of 9-131 regarding detaining someone and quote-unquote honoring a detainer, where we detain someone longer than their normal custody time.
Yes.
So what our policy is based on is the subdivision H of 9-131, which is permits communication of a discharge date when you have a detainer that doesn't have, even if it doesn't have a judicial warrant, and there is either a qualifying conviction or the terrorist watch list, those qualifiers. That's the communication that happens in limited circumstances. And in that instance, that's where we do a review. It comes to the legal division. Does someone have this detainer request? Yes. Is it supported by an administrative warrant that establishes probable cause that the person is subject to removal proceedings? Yes. And then further assessments. Do they have a qualifying conviction? Is there any other qualifiers, or is there some other circumstance that we should not making the notification? So when I talked about in the testimony about the 18 transfers in 2024, the 25 in 2025, those were the circumstances. Our policies are clear, and our guidance from our attorneys and myself when we respond back to the ICE unit or anyone who inquires of us, it's that the individual is not to be detained any longer than the normal discharge procedures. And that's our policy, and that's our legal division mandate and guidance to that. So in those circumstances, we are not conventionally honoring a detainer. Honoring a detainer means,
Correct, yes.
You know what it means.
Yes.
It's where we keep someone longer than we should.
Which is prohibited, yes.
And that's not what our policy dictates and our practices are.
Well, thank you for that clarification. That's important. And yes, it's not about honoring a detainer request, but it's the communication information in those instances about discharge day. What is your understanding of the warrant requirement there? Is it is it an administrative warrant, or is it a judicial warrant? What is your understanding of the law as to when that communication about a discharge happens, and how do you ensure that requirement is being met? That warrant requirement.
So under the communication, it is a detainer request, which is a formal form that's submitted to us, and it's also supplemented universally. I've never seen it without it. An administrative warrant that is signed by an immigration official that establishes the probable cause. That's in opposite of the judicial warrant. The judicial warrant would, in coordination with all the other qualifying convictions and otherwise, allow us to detain someone. So our practice is when we review the paperwork, if any of those aspects, paperwork-wise, is missing, we will not make a communication. We will deny or direct the ICE unit or anyone else to not make this communication or other.
Thank you. I'm trying to go for questions. Yes, I think Councilmember Brewer has questions.
Thank you. You talked about training, and it's great that you're doing it. So do you do it for everybody? Do you hire outside, internal? And then, of course, if people, some situations may be after 9 to 5. So who would people complain to, if they had a situation? So just generally training.
So training in general so far has been done primarily by myself or other members of the legal division. So I have attorneys and I have 2 deputy general counsels. So we've both and all have presented, again, mostly at the promotional trainings. How we roll this out more widespread, we're actually we're working with our Deputy Commissioner of Training now to 2 things: to get into the recruit classes. So that's most important because you get people fresh and coming into the department, so they don't have a misunderstanding from day one as to what our limitations are.
You have a class coming up?
There's one in now, and I'm actually trying to we're figuring out and coordinating when we could get in to speak to them about that. So there's 260-something new recruits that are going through the academy. Subsequent to that, we'd also, again, we want to, what the Deputy Commissioner of Training is building out is an in-service training course that would require on an annual basis officers come for, I forget exactly what the term is, maybe a 3, 4, 5-day training, something along those lines. And we're going to work with him to ensure that we are part of that. And this is part of that, somewhere within the block to make sure that everyone's getting an annual refresher on what the laws are and updates, right? Because they could be updated and changed. And we want to make sure, in addition to just issuing a teletype, which is important because that is intended to reach all members of the service, that it's also this in-person, we give you the guidance and let you know even the nuances of what you may encounter.
And if people see something, an infraction, but it's after hours, you said normally they would call you. So how would they do that if you're not there?
Well, we have a 24-hour legal line. We have an attorney of the day who's on call. I'll just be candid. My phone is never off. So if it's something that has to come directly to me, I will answer it. In addition to that, we have a legal intake email address. that is often used, and it's not that somebody will not be available. We do have the availability for that, and also our grievances if that was another avenue to make a complaint. But I think we're more talking about someone from the outside or a legal person, and we are available. We do have attorneys on call 7 days a week.
And then do you also, because the situation we heard earlier from legal services, obviously pre-administration, no transparency, et cetera. So it sounds to me like that's not going to happen again. But do you talk to legal services about these issues, or is that a no-no?
No, I've had a number of conversations, in special circumstances or even allaying fears. People think that we might be honoring something and we're not. And as it turns out, the people, the individuals were released. So I've been accessible. Yeah, and again, we can have these conversations. I think we want to gauge the defenders on different things. Particularly as we've talked about. Councilmember Brewer, the visits, attorney visits. So I'm not opposed to having this be one of the conversations.
Okay. And then I should know this, but in social services, we never ask people their immigration status. Is that also true in correction?
Yes, that is. We don't inquire about the legality or illegality of their presence here.
Okay. And then how would, I guess what I'm trying to think of, how would any interaction, I guess the way you're trying to prevent what has happened in the past is by training. Is that sort of what you're saying?
That's a start. That's the start.
Okay. Are there any other places where you could be more transparent, or that in addition to the training, so that ICE doesn't have any input?
Well, I think that what DOI recommended and we started to do with at least whoever we're in a partnership with now is communicating with their leadership as to what our limitations and obligations are, and making clear that we are only able to do whatever the enforcement is, criminal enforcement, intelligence gathering. So that's another avenue. So it's the training, communications with the partnerships, and then supervision, right? So making sure that the supervisors are aware and that this obligation to notify the legal division or to notify particularized units is complied with. It's part of policy, and that there's multiple levels of oversight, not only from us on the legal side and the administrative side, but direct supervision of the officers themselves and then communication with agency partners.
And is the union leadership aware of what you're doing and also hopefully supportive?
We haven't spoken to them about it. I mean, we do the trainings, and I could certainly communicate that if we think that's beneficial. But I've not been, I've never encountered a union leader that would be opposed to more robust training for any of its members. So I think wouldn't be a concern, but I'll certainly convey that to the union leadership.
Okay. Thank you.
I'd like to note that the Deputy Speaker, Natasha Williams, is on Zoom, and now we'll turn it over to Councilmember Aviles. Or is Councilmember Aviles not here? Okay. When she comes back, we'll turn it over to her. So I just want to go back to something, Deputy Commissioner, which this was on my mind too, because we talked about administrative warrants, but I just checked on the administrative code, and in section 9-131 requires the department may only honor a civil immigration detainer by holding someone beyond the time or by notifying federal immigration authorities of such a person's release when the immigration authorities present the department with a judicial warrant for the detention of the person. So there is a judicial warrant requirement, and I'm not understanding why notification is happening without the presentation of a judicial warrant, as opposed to administrative.
Yeah, the policy is based on subdivision H of 9-131, which doesn't contemplate the honoring of it's persons not to be detained, and it talks about the communications. So what it says is shall not communicate about a discharge or, there's other provisions. I'm sorry, I don't have the language memorized, but it's in that subdivision H, unless, and then it has the qualifying conviction and the person's appearance on a terror watch list. So you have the presence of the detainer, and we're not permitted to honor the detainer, right? That's clear. We don't honor the detainer absent a judicial warrant and the qualifiers, but in the communication aspect pursuant to subdivision H, there is that ability to communicate about the discharge date, which is, not primarily, that's what these interactions are. And it requires the detainer essentially, and does not require the judicial warrant for the communication, and then the qualifiers as far as the convictions and otherwise.
But what I'm having a hard time understanding is how does Section 8 operate? If you look at Section B1, right, it says, I'm going to read it again, the department may only honor a civil immigration detainer by holding a person beyond the time when such person would be otherwise released from custody, which you all don't do, or by notifying federal immigration authorities of such person's release. So it's the notification of release in Section B1 that is only supposed to be happening with the judicial warrant. And I'm also wondering, how does subsection H override that?
I still do believe and think that, and again, this is longstanding policy that's been over 2 mayoral administrations and through Moya and also, the city law department as its interpretation. My understanding and longstanding understanding is that that first subdivision really specifically applies to continued detention. So it's not just as about the notification as to the release date. It's the existence of the person's presence in custody, and also honoring it, meaning keeping the person in custody beyond their normal discharge time. The subdivision H is merely the notification of the discharge time without any honoring or continued detention pursuant to the detainer absent a judicial warrant. And I'm not trying to be coy. I mean,
No,
yes.
And I think if you all can provide some guidance to this committee too about that, because I'm also trying to understand. I understand it's been longstanding policy, but notification is written in the statute above, and it seems that we're in the interpretation reading out that section.
Right.
I'd be curious to see, and if you can provide this committee with the.
We'll certainly
legal
have a
interpretation of
follow-up
that.
where we outline that better. It's hard to do, sitting
Back and
here
forth,
without
right.
paper and stuff.
Yep. We'll turn it over to Councilman Rabiles who had questions.
Thank you so much, chairs. I'm sorry, give me 1 second. I had it open. Apologies, since I've been in and out, you may have answered this question 17 times. So forgive me if that is in fact the case. But can you tell me, the DOC ICE unit, how many people are in this unit? And what is exactly the unit does?
So it's a subdivision of, or a subunit, I'd say, of our custody management unit. It's comprised of, it's very few people. I think it's 3 or 4 captains that are active permanently and or temporarily assigned there that assist with this. We need to stand up a unit in these circumstances to see and have a main point of contact for whenever there is an ICE detainer or there needs to be an inquiry for someone to call and see if any communication or if the ICE detainer is valid or in place or what the obligations are. So it's just merely a subunit, very small subunit of the custody management division that deals with these, reviews them, gives us the paperwork, communicates with the legal division as to, again, the paperwork processes, qualifying convictions or otherwise, and then they will clear, quote unquote, clear the warrant, meaning to have the person discharged normally, or otherwise make this communication directly with immigration officials that we've been discussing.
Got it, thank you. And in terms of, we understand NYPD has a much more extensive guidance. What is the guidance that DOC has provided in terms of how they're documenting requests that are coming in and that process?
Yeah, so I mean, the guidance, we actually have what I'd consider pretty extensive guidance on this. I mean, it's a 19-page policy. There's multiple forms. The ICE unit has its own internal protocols where they do track, this is where we get the information for our local reporting, the local law reporting, and also, our own edification of what the process and numbers look like. So they have their own internal protocols, and then our policy is pretty robust when it comes to what the obligations are, where things are documented, and where they have to go. So I wouldn't say that it's more limited. I mean, by their very nature, the PD has a much broader scope of what they have to do. Ours is narrow and focused, but I do think, again, a 19-page directive plus our teletypes, which outline the obligations, and that's written guidance. That's independent of whatever we do for, again, what we're building out as training.
Great. Would you be able to provide that to the council for review?
I think it is in the DOI. We certainly will, but it's in the
great.
DOI report as attachments.
Great, okay. In terms of, would the recommendations adopted by DOC have prevented DOC from sharing information about Mr. Villanueva?
I do think primarily the one main recommendation, as I mentioned to the chair earlier, is the training aspect. I do believe in the nature of this interaction and the seeming misunderstanding or just lack of guidance that was given to the CIB officer that was involved, officers that were involved. I think stems from primarily the absence of or lack or not adequate enough training, which we look to fix. So I think there's multiple layers here. The other recommendations go towards finding out other incidents, but I think on these specific incidents, the training would have really made a difference.
Do you think the guidelines of the framework and guidelines of the law are too confusing? If we were to simplify the law to make it more straightforward, would that help in this regard?
I think, quite candidly, to me, they're not. I mean, it's nuanced, and it could be difficult for the layperson to understand, and I do appreciate that. But we do make, and it's my job to make the training and the guidance internally unequivocal and clear. And I think we're able to do that within the boundaries of the law, so I really can't speak on how other people interpret.
I appreciate that, but we've had these laws on the books for well over a decade, and there seems to be some level of confusion. So it seems like perhaps streamlining the law and making it clearer would help both our employees ensure that they can follow it, as well as the public to be able to articulate where the bounds of the laws potentially fail. So it feels like we should be looking at the policies and making sure if they seem to be confusing for anyone that we clarify that. Because we're going to train forever, and clearly we're seeing violations continuing to happen. So something is wrong with the pie. In terms of the purpose, we've seen this with NYPD. In terms of the recommendation around asking federal law enforcement to identify the purpose of the immigration request to ensure that it's legitimate law enforcement purpose, can you talk to us a little bit about that? That was a problem with NYPD as well. There were not real verifications because this engagement we see is based on relationship. Just a courtesy, law enforcement to law enforcement. So how are you training, and what is the guidance to make sure there is an actual, real law enforcement immigration issue?
Yeah, sure, yeah. I mentioned earlier that we do have a very limited group of people that are actively engaged. I mean, right now it's 3, and it doesn't go much beyond, several more whenever we have these federal partnerships. So obviously the primary focus of that is to get to those individuals so that our personnel have a clear understanding as to what their limitations and obligations are and what our policy and the laws of the City of New York are. Additionally, we've engaged now the leadership in those task forces from the federal agencies, which gives the guidance, and I've been, again, unequivocal with them as to what we cannot be doing, and they've been receptive to that. So we do have those 2 guardrails, but I also think there's, again, any other types of things that we can do. The scripted, I think one of the recommendations here was like the scripted questions becomes a little unwieldy, and obviously has been mentioned here, does that necessarily give us the answer? I want our officers to be able to appreciate and understand on their own without asking the questions as to what's happening here, and if there's a tinge of hesitance on their part, to communicate with their supervisors and leadership within the agency to make sure that this interaction, communication, and working arrangement is compliant with the local laws.
So how do the officers, a small unit obviously, how do they verify that what they are being told is in fact the case?
Yeah, they go through us. I'm sorry to interrupt
can
you. I apologize.
Can you walk me through? What does an officer do? Receives a call from DHS in Arizona, says, hey, I need this, whatever. What are the protocols? What does the officer do then to verify that that is in fact the case and it is within the bounds of the law? What are their next steps?
Yeah, so that scenario doesn't really happen in that way. The interactions that we've had here are where there was a working relationship in the task force, and there was an understanding, at least what the initial purpose of the task force was this criminal enforcement. There was an operation that they actually named, and that was what DOI found to be the understanding of the correction officer. So in those circumstances, if there's an understanding and something kind of lends outwards from that seemingly is in furtherance of any immigration enforcement, our instruction now, particularly since we've trained those individuals in the wake of the DOI report, is clear. Contact the legal division. So that is, if there's any uncertainty or ambiguity in what the nature of the enforcement is, or the scope seems to be outside of what the criminal or intelligence gathering purpose is, they have to make that communication. That's actually the process. Any other communication, I would say, is squarely limited and prohibited without the consent and advice of the ICE unit and the legal division. That's what our policy dictates.
So in the context of NYPD, and maybe this is outside here, an officer calls another officer in a task force. They have a relationship. They claim a legitimate criminal activity, which would immediately, you'd assess that is within the bounds of the law. The officer takes it because they have a relationship. They work together all the time. We found, in fact, there was no criminal basis. And there was no protocol for that officer to then verify that that criminal basis that was told to them was, in fact, not legitimate. So I guess my question is, within the bounds of these relationships, right, where there's trust and colleagues, how do officers verify that the stuff that they are being told, the context for a detainer, is in fact true?
So you're asking, it's actually a really difficult question. I don't know that there's an answer around. I mean,
we've seen it happen. So I was just curious, like what kind of protocols NYPD asserts it saw that instance and is added an additional layer of guardrails there. So I guess in this same context, given the nature of these relationships, what are the additional guardrails do you think would be apropos to ensure that officers are not getting caught in that scenario?
I mean, I hate to repeat myself in this, but I think it is the interaction with supervisors, the legal division, the the ICE unit, anyone else that has more knowledge and basis of knowledge of this. I mean, if you're asking me a scenario where they say, no, it's criminal, we're not doing anything else, and then we're just working with them, and then something happens on that end, it's a very difficult, I mean, that may be the time to explore the relationship, right? But I mean, these federal partnerships, we have to have a level, I mean, I'm just being honest, we have to have a level of professional trust and ethics in terms of your obligations to comply with the local laws and otherwise, because they are fruitful to us.
I mean, if we had a federal government that actually was following the law, I could follow that rationale. But we are in a new context, in a new terrain where the law doesn't actually apply and they're not following it. So I would insert some skepticism and way to verify that what is actually being told is in fact the case. I know that's difficult because there are relationships. However, we are in a very different situation. And I think I would urge the department to really consider if there is an additional layer of verification, both to protect, honestly, the staffers whose responsibility it is to follow the law of New York City, but also want to protect their professional relationships. So I would just urge and encourage a little bit more interrogation and placement of guardrails there, because that is where we see the most serious infractions occurring, is in this interpersonal relationships of trust.
And I think we certainly could explore that with the committee and the audit, the audit that we're doing with the city partners. So we'll bring that to them and make that part of our assessment.
Thank you. Thank you, chairs.
Thank you, Council Member. Those were great questions. I wanted to go to another topic that Councilman Avila sort of covered too, but just to go through again. So when was the most recent training that DOC had done for staff, and what is the frequency now that we're doing?
So we did the trainings immediately subsequent to the DOI, becoming aware of the incidents. So that was about April and May. I actually sat down with the individuals involved right away, them and the supervisors, and just went through the practices and policies. We developed the training, and that was done. We've brought it to, I'm sorry, I'd have to get back to you as the exact date of it, but when we get into the recruit classes, that's something that's been done. We've had an assistant commissioner assigned to oversee the Central Intelligence Bureau, CIB, of which these officers were assigned. We've engaged with him and done some training for him as to our limitations and obligations under this. And then what I would like to do, I would like to have this at a minimum of an annual training with these specialized units. So we are coming up on a year where that would happen. But again, we are also trying to get into the current academy class and then, do some updated training department-wide as soon as we could figure out how best to manage that.
And for new DOC employees coming in, are they required to take the training? Is there a mandated deadline or timeline for new employees to take the training?
There's not yet. But as I said, I'm working with the Deputy Commissioner of Training to get into the recruit classes. Those are the most important people I think we could get at the beginning of their careers. So that's going to be happening. As I said, we do have a class in now. We're going to try to find blocks to get in for this class. At a minimum, we'll be starting with all new recruit classes.
Got it. Okay. And going back to the DOI report, DOI reviewed 5 emails. They discovered 1 instance of improper immigration enforcement. Were you all aware of this incident before the DOI report? If so, had you all alerted DOI or other agencies? What was your knowledge, or what was the agency's knowledge of this?
We didn't have an awareness of that until DOI brought it to our attention.
I see. So going forward, how do we address that, right? Because I think it came up because DOI did the investigation, but I think part of what's critical right now, too, is to make sure that the agency proactively knows of these instances, ideally before an investigative agency comes in.
Right. And again, this is all what we're talking about. How do we achieve that? Because we do want to achieve it, and what's the best mechanism for it? Will it be targeted email audits? Will it be inquiries? Will it be the training? Will it be exploring the partnerships? There's a lot of ways to do it. I'm sorry that I can't give a real fulsome answer to that. I think it's something that we will be addressing with the administration and the, again, the committee. So I don't want to say affirmatively what we could do. There's a lot of options, I think, that we could explore and figure out and manage what works best in that circumstance.
And in that sense, too, will you all be able to provide the committee with the training materials you all are using now to train employees? I'm assuming you have a set of them already created?
Yeah, I think we can. Let me bring it back. I want to talk because, again, some of this is developed by the law department and some of it. Sure. So let me consult with those partners that we have, and we'll get it. I don't have personal opposition to it, but let me just clarify before I make an affirmative representation.
Sure, and I do think it'd be important because part of this is all oversight and part of this is moving on from what we've seen before. Mm-hmm. That'd be good to have transparency into how employees are being trained.
Absolutely.
At the time of DOI's report, DOI found that DOC had not reissued Operations Order 919, describing the circumstances about when DOC may communicate information or assist federal immigration authorities. Has the order now been updated and reissued?
The policy wasn't updated in any way. The policy is still the same, but nonetheless, in May of 2025, we reissued a teletype with the policy reiterating that that's in effect. It should be complied with. The teletype, which is kind of a department-wide message, indicated what the obligations are. If you have any of these interactions, you must go to legal and ICE. I think DOI indicated that. So yes, in May of 2025, it was reissued. I think, like I said, I'd like to get on it at a minimum an annual cadence of that. So we're approaching that time when we reissue it again and have it read at the roll calls.
And just a few more questions from my end too. Going back to the CIB investigator involved in the cases of Concepcion and Villanueva, where they were impermissibly transferred over to ICE in violation of the law. The investigator's duties were primarily responding to information requests, answering phone calls, and replying to emails, right?
I'm sorry, could you repeat that?
The investigator's duties were primarily responding to information requests, answering phone calls, and replying to emails. Isn't that what the report stated?
I mean, in the context of this, yes, but I mean, that's not our officers, especially in the Correction Intelligence Bureau's functions. They're actually to engage in investigation and otherwise. So I don't, again, apologize with the section you're referring to specifically, but I don't know that I'd characterize the main role of those officers just be doing what seemingly is administrative.
So it was a more intelligence and surveillance, I guess, type.
Yeah, I mean, that's what their assignment is as a global matter. Again, this might be nuanced and specific to this, but ordinarily we wouldn't waste, that kind of resource of just doing administrative work.
And then were any of the investigators' supervisors aware of what was happening, or it sounds like I would assume not, because DOC wasn't aware of it till DOI came in. But were any of the investigators aware, was any of the investigator supervisors aware of the communications there?
I think they're aware of the communications, but I do believe that the same issue arose as to the understanding of the nature of it. So the supervisor was interviewed by DOI, and they also found the same issue, that there was the lack of training and the lack of guidance. So, again, that's why I've reiterated that the supervisor training is important as anything else. And I just would add, again, that there's since been an additional layer of supervision added to CIB. So, we're kind of making it more robust all around.
I see, okay. And then looking at the DOI second and third recommendations, it seems like, is it now that the policy is to route all questions on civil immigration enforcement to the ICE unit? Is that correct?
ICE and legal general counsel.
And licensed general
Yes,
counsel.
yes.
And had that not happened in the case of both of these individuals? Was that part of the reason why they were improperly transferred as well? Or were the requests routed to the ICE unit at the time?
No, I think this wasn't, again, because of the nature of the cooperation in the task force, it wasn't what we contemplate to be a formal inquiry or something outside of that. Again, I want to stress, I'm not mitigating the outcome here, but it was what is deemed to be inadvertent. It was something that there was a misunderstanding of the nature of that. So in that circumstance, when there's a belief that the interaction was in furtherance of some type of criminal work or investigative work or intelligence building, that wouldn't require notification to us. What we're requiring and encouraging and stressing is that when it becomes unclear, or if there's any level of uncertainty as to what the nature of the communication or the interaction is, to then come to, raise it up, and that would be through the ICE unit and us.
And recommendation 5 from the report had talked about informing senior federal officials with whom DOC regularly collaborates with about sanctuary city requirements. Has DOE, since the investigation and report, communicated with federal partners, these are what our sanctuary laws are, and these are our policies to make sure we comply with them?
Yes. We met, I have the dates, I just sent it to DOI. We'll follow up with the dates, but it was, I believe, December and this month, February, not this month, December of 2025 and February of this year. I met myself with supervisors from the Alcohol, Tobacco, and Firearms, with which we have 2 officers assigned, and I also met in February with the U.S. Marshals, supervisors from the U.S. Marshals Office, of which we have 1 officer assigned. As of October 2025, we don't have participation in the task force with HSI, and we currently don't have active task force participation. So if and when that is explored and expanded, my obligation and a commitment will be to have similar communications at the outset with those supervisors in those units and agencies.
Thank you. And so, I wanted to just revisit, I think, the importance of that discussion we were having before about the 9-131, because I did read quickly subsection H2, and I'm not seeing, I think it would be helpful for DOC and Corp Counsel, the law department, to provide, their law on this too, their explanation, but I'm not seeing the 2 provisions as in tension with each other. I mean, H talks about the use of city resources and when that could be allowed for communication, and it says, violent crimes as one of them too. But the prior one, B, that we were talking about, talks about, notification as well, and does so in the context of a judicial warrant. And it seems like both of those 2 are not inconsistent with each other. One talks about violent crimes as the time to use city resources, and one talks about a warrant requirement. And the reason why I bring that up is because the warrant requirement is such an ironclad requirement in the criminal context, in this context too, given, and that's really my concluding point, is given that, there are so many individual instances, and DOC being such a large agency too, there's so many individual instances or potential instances where that kind of impermissible collaboration and communication could occur. It does seem like, the legal counsel's office reviewing whether not just administrative warrant, but judicial warrant paperwork or things like that could be a very important way, as we were talking about, to ensure that there are not gaps in oversight simply because the agency is so big. And so that may be one way to assist with that, especially if the warrant requirement is a judicial one. So any guidance there from you all would be very much appreciated.
We'll follow up on that point again, because it's hard to legal brief that issue now.
Totally.
So we'll get back to you on that.
Yeah, and likewise, too, I think the training materials would be very helpful as well.
Sure.
That concludes the questions from our end. Thank you all for your testimony. And you know, as I said too, I do think going forward with the new administration, it's my hope there's a lot of work to do going forward at the agency as well to correct these transgressions from the past and to put inside really robust training and then accountability to make sure that training is being complied with. So I look forward to continued conversation and discussion and testimony around these issues going forward.
Thank you, Chair. Appreciate the opportunity.
Thank you. We are now going to open up the hearing for public testimony. I remind members of the public that this is a government proceeding and that decorum shall be observed at all times. As such, members of the public shall remain silent at all times. The witness table is reserved for people who wish to testify. No video recording or photography is allowed from the witness table. Further, members of the public may not present audio or video recordings as testimony, but may submit transcripts of such recordings to Sergeant-at-Arms for inclusion in the hearing record. If you wish to speak at today's hearing, please fill out an appearance card with the Sergeant-at-Arms and wait to be recognized. When you are recognized, you'll have 2 minutes to speak on today's oversight hearing topic, the Department of Investigations report on agency compliance with sanctuary-related local laws. If you have a written statement or additional written testimony you may wish to submit for the record, please provide a copy of that testimony to the Sergeant-at-Arms. You may also email written testimony to testimony@council.nyc.gov within 72 hours to close this hearing. Audio and video recordings will not be accepted. For in-person panelists, please come up to the table once your name has been called. And now I will call our first panel, which is Zachary Ahmad from New York Civil Liberties Union, Jason Taper from Surveillance Technology Operations Project, and Tanya Matos from Unlocal.
If we don't see Zach, could we also call Ben? Yeah. I think Chanel requested that.
Is Zach Ahmad from NYCLU here? No? Okay, then we'll also call up Ben McCoubry from NILAG. Thank you all. You may begin, Jason, and I'm going to be standing, but I've been sitting for a while, but I'm still listening just as carefully.
Thank you, Chair Krishnan. Good afternoon. My name is Jason Taper, and I am a legal fellow with the Surveillance Technology Oversight Project, or STOP. We advocate and litigate for New Yorkers' privacy rights, fighting discriminatory surveillance, which is the subject I would like to focus on. But first, I'd like to echo the rest of the ICE Out Coalition and call for this council to pass the Trust Act, establish a universal right to counsel in immigration cases, and abolish the so-called gang database because ICE uses presence in a gang database as pretext for deportations. Regarding the previous administration, former Mayor Adams' complicity with ICE was both immoral and illegal. Though we are worried about the incomplete accounting provided by the Department of Corrections earlier, we are thankful that Mayor Mamdani has turned the page and is an ally in the fight against ICE. But unfortunately, the end of Adams' mayoralty was not the end of this problem. The infrastructure that Adams put in place is still here, and every day it still exists. The surveillance that we undergo risks giving ICE our private information. In order to truly be a sanctuary, we need to not just end collaboration with ICE itself, but also to end our city's complicity with the spyware companies that enable the horror that ICE inflicts. Let's name names. Our city public hospitals partner with Palantir. Palantir, as you may know, is an essential part of ICE's dragnet. Our tax dollars and our sensitive health data should not go to companies that support ICE. And no one should have to forego healthcare or any other essential service out of fear their data will end up with ICE. As another example, Clearview AI is a facial recognition company with a $10 million contract with ICE and a contract with FDNY. Again, New York tax dollars supporting a key tool for ICE. It is exactly because ICE needs the collusion of local governments and spyware companies that New York City must end contract with Palantir, Clearview, and big surveillance more generally. And it's not enough simply to stop actively giving ICE's spyware companies our tax dollars. We need to cut off the data pipeline. No more sharing data without a real warrant signed by a judge. And importantly, we need to minimize the data we collect in the first place, because the only way to truly make sure ICE doesn't get their hands on our information is not to collect it in the first place. To conclude, we know that ICE's oppression is fueled by the collusion of local governments and spyware companies, but New York City can be a shining example that there are tangible, concrete ways that cities can fight for our immigrants' neighbors. We can tear down the partnerships with big surveillance that fuel ICE, and we will not, in fact, rest until we abolish ICE and power down our city's authoritarian surveillance. Thank you.
Good afternoon. Thank you to the Committee on Investigations and Oversight for holding this public hearing to address the urgent need to protect our immigrant communities in New York City. My name is Tania Matos. I'm the Executive Director of Unlocal, an immigration legal nonprofit providing immigration legal services. We are also part of the Pro Se Plus project and the Rapid Response Legal Collaborative. I'm here to express my deep concern for our sanctuary laws and the breaches we have witnessed. Every day we work with individuals and families whose safety depends on whether the city truly holds up its sanctuary laws. We are living through a period of escalating detention and deportation. In this climate, New York City's sanctuary laws are not just symbolic, they are life-saving. They prevent more New Yorkers from being funneled into detention where people face neglect, prolonged confinement, and in some cases, even death. They also strengthen public safety by ensuring immigrant New Yorkers can interact with local government without fear that their information will be shared with ICE. When that trust is undermined, the consequences are immediate. We have worked with individuals who are afraid to seek protection because they feared going to court, and to court could expose them to immigration enforcement. We have advised parents who hesitated to access services for their US citizen children out of fear it would put their family at risk. Even the perception that city agencies like NYPD and DOC are communicating with ICE and collaborating with Donald Trump and Stephen Miller's unconstitutional policies creates a ripple effect, keeping people from reporting crimes, cooperating with investigations, or seeking emergency assistance, and even talking to their teachers within the Department of Education. This is why the passage of the New York City Trust Act is critical, and that is why continued support for the Pro Se Plus project and Rapid Response Legal Collaborative is so vital. These protections ensure that safety and due process remain real for all New Yorkers. Thank you.
Good afternoon, and thank you to the City Council for having this hearing. My name is Benjamin Remy, and I'm a Senior Coordinating Attorney at the New York Legal Assistance Group. I'm here today specifically to speak a little bit about what is happening inside of our immigration courthouses, which are just down the street from where we sit now. As some of you may be aware, I have been on the ground every single day at the immigration courthouses since ICE began detaining people at two of our immigration courts here in New York City, 26 Federal Plaza and 290 Broadway. My introduction to this phenomenon of ICE enforcement, which was unprecedented in our New York City immigration courts, was a mother who was brutally thrown to the ground right in front of me after her routine court hearing. Despite pleading with ICE agents that she had a child in school that she needed to be home for when her child returned home from school, she was thrown on the ground with a knee placed on her back as she continued to scream for her children. Little did I know that this was just a very small preview of the cruelty that I would see only increase and intensify over the following months. Months later, I was standing in front of another courtroom surrounded by masked federal agents. As people began leaving the courtroom, the door opened and the first man to walk through naturally took a step back when he saw masked agents in front of him. The agents interpreted this as resisting and began screaming at him and tackled him to the floor, wrestled with him for several minutes while there were small children only feet behind him. I heard him begin screaming in agony and realized that he had been handcuffed so poorly that his wrist was bent at an extreme angle, and there was actually blood coming out of his wrist and onto the floor from the incorrect placement of the handcuffs. When I demanded that those federal agents fix those handcuffs, I was told that he wasn't even on their supposed list for immigration enforcement that day. Today, although the raw number of daily detentions in our courts have decreased, we still see the same level of brutality and cruelty when these detentions are made. We still see families split apart on a daily basis, and people who are doing their best to follow the rules and come to court with the document that they were instructed, that instructs them to be in court that day, are being punished for doing so. Just last week, I walked out with someone who had just finished with their routine hearing, and in the elevator, he confided in me that he had not slept at all the night before. He had just prayed and prayed the entire night that he would make it back home the next day. If there's anything that this evolution in ICE courthouse activity has taught me, is that our work is far from done. ICE has demonstrated that they have no respect for our sanctuary laws here in New York City, and we must continue to work tirelessly to ensure that our institutions do not collude with the Department of Homeland Security. Finally, it is also imperative that City Council ensure that our immigrants have places to go for advice and support so that they can make informed decisions about how to best navigate today's treacherous landscape. This includes funding the work of legal service providers and community-based organizations who have proven their capacity to adapt to meet the needs of the immigrant community members and have built relationships of trust with all of the diverse communities across our beautiful city. Thank you.
Thank you very much. I just have a couple follow-up questions. One is, as you all know, we've seen what happened at Canal Street, 26 Federal Plaza, as you testified to as well. How have these recent incidents and the work that you all have done, what have they shown to you about how they've impacted the willingness of the immigrant community to interact with law enforcement when they're the victim of a crime, to reach out to government when they need help or services in other ways? How has this had an effect on immigrant New Yorkers?
I'll take that. So I think the effect has been profound in a really horrific way. We've seen this climate of fear that has been cultivated by ICE enforcement, and it is now very deeply entrenched within the immigrant community. And I see folks every day when I go to court that are shaking when they enter the immigration court, that are oftentimes in tears before they even make it to their courtroom. They go online, they see the videos, they see everything that's happening at these courthouses, and they're terrified to show up. And they become placed in this impossible situation where they can either continue with their case and do the quote unquote correct thing and go about things the correct way, but they risk being detained, or they don't show up for court, they're ordered removed in absentia, and they lose any ability in the future to pursue their case. So it's an impossible situation for folks, and I have absolutely seen that extended to city institutions as well. Mothers that are nervous about getting prenatal care at hospitals because of lack of immigration status, and a concern that the government the city government will be sharing information with federal authorities. Kids that are afraid to go to school, people that are afraid to even go to a Social Security office to get their Social Security card, which they're entitled to when they have work authorization. So I see this on a daily basis of people being absolutely terrified, one, to show up to court, and two, to utilize any basic services that we have here in the city.
I'll just add that I've also seen that happen with individuals that have no immigration court hearing coming up, but they've lived here for 30 years, 40 years. They're afraid to go to the hospital. They're asking for accompaniment to go to the hospital because they're afraid, or they heard in the news that immigration is outside of a hospital. It doesn't help that immigration is going into Columbia University, is standing outside of Department of Education schools that we've heard in Corona, Queens happen. We've had principals call me and wave the flag that immigration is outside of their school, though not on the school premises, but at that moment we have to advise them and tell them to kind of lock down and make sure that they implement their safety protocol. But families are very nervous to do everyday things, and I know many also organizations that are trying to buy groceries for families, again, get them medication for individuals who are very afraid to step out their house.
Thank you. And my final question, and this may be more for, or any of you on the panel, frankly, is civil rights groups have raised concerns about the Fusion Center at Rikers. From a legal defense perspective, how does the real-time sharing of data through these centers undermine the judicial requirement that we've been talking about found in our detainer laws? If you can answer.
Gladly. STOP has a report out on fusion centers, which I can link to in my written testimony, which I will be submitting later. It completely undermines it. It is a direct and opaque process by which essentially there is a deputization of anyone in that fusion center for ICE. any information that is collected by any agency, we have to assume is shared between every agency involved in these joint task forces, fusion centers, et cetera. These are the nexuses, if that's the proper plural, of the information sharing and the ways by which ICE gets a handle on our information. It makes legal defense, or frankly, even knowing what the case is and what's going to happen in the first place, much harder.
Thank you, and thank you all for your testimony. The next panel we have is Michael Loeb, Christina from, I can't read the last name fully, but from the Proceris Project, Krishna, sorry, from the Proceris Project, and Lucky Ho from the Asian American Federation. You may begin.
My name is Michael Ilan Loeb. I have a lot of friends who are immigrants. I come from a family of refugees and immigrants, and I'm at Federal Plaza at least once a week. Before I begin, I want to mention that in just one season, ICE agents have brought shame and negative attention to all law enforcement. So if I were a law enforcement professional of any type, I would not want to be in a position where my reputation or my safety had to rely on them at all. They're like an ethical negative Midas touch, and if a surge comes, we need to be ready to deal with that. Part two, when you get this wrong, the consequences can be extremely serious. So you cannot bring back meaningfully someone who has been deported and lost their job while they were detained, or whose family is terrified. You cannot repair those things. And part three, I'd say that DOC, NYPD, and ICE have three basic mandates: to enforce the law, to protect, and to serve. ICE's remit specifically to enforce immigration law, and I challenge any of you here to spend one full morning in an immigration court at Federal Plaza or a pro se asylum clinic and return convinced that U.S. immigration laws are just or transparent or being applied with anything less than caprice, selfishness, short-sightedness, and cruelty. So enforcing very bad law is very bad, and that is the case even before we talk about the tactics deployed by dangerous, hastily trained, and small ICE officers. They enforce bad laws badly. They should be abolished and all associated miscreants investigated, but that's not happening. So until that day, all safety personnel are rewarded handsomely to protect us, and that sometimes happens, but many New Yorkers with justification don't trust the NYPD or DOC. We're rightfully cautious and can't leave anything to the decision-making of individual officers. And finally, to serve, the question is whose interests are being served. We saw disgraced former Mayor Adams take the deal. We saw it. And he was willing to trade his own freedom and a handful of upgrades for our freedom. ICE, EOIR, and DHS officers serve the interests of elites who don't care about any of us at the pleasure of Secretary Noem and Felonious Trump. So they're profiting from concentration camps. We have sanctuary laws to keep the correct people, everyday New Yorkers, as the focus of service. Thank you.
Thank you.
Good morning. My name is Christina Garrity, and I'm the coordinator for the Pro Se Plus project, a collaborative made up of 4 legal service providers and 2 community-based organizations. In the past 3 years, the Pro Se Plus project, otherwise known as PSPP, has worked tirelessly to meet the needs of immigrant New Yorkers who are unable to retain high-quality legal counsel and must navigate our labyrinthine immigration system pro se. As I'm sure many council members are aware, people who are represented can appear in immigration court online, meaning that it's pro se respondents, the people our project is designed to serve, who have been detained by ICE when appearing for routine appointments. Thanks to the flexibility of our projects model and the generosity of City Council, PSPP partners have been on the ground at 26 Federal Plaza and 290 Broadway since the courthouse arrests started happening. This has put us on the front lines of the Trump administration's assault on our collective right to due process and the integrity of our city's sanctuary laws. As my colleagues Tanya and Benjamin have already discussed, we have seen firsthand the horrific consequences of the Department of Homeland Security's unprecedented expansion of unchecked power. This includes not only the violent, unlawful detention of immigrant New Yorkers who are complying with reporting requirements, but a general undermining of our faith in public institutions. The fear created by the presence of federal immigration officers in courthouses drives community members who feel they have no other option to miss hearings and check-ins, precipitating orders of removal that will soon be impossible to appeal. If there is anything that our on-the-ground experience has taught us, it's that we can count on ICE to willfully push the boundaries created by our local laws. When this happens, it is not only immigrants who lose, but all New Yorkers. To that end, I commend the committee's commitment to ensuring the NYPD and DOC's compliance with sanctuary laws. I close by insisting on the importance of funding services for communities most vulnerable to escalating detention and deportation. This includes not only PSPP, but pro se service providers in the Asylum Seeker Legal Assistance Network and beyond. Thank you very much for this opportunity to testify.
Thank you.
All right, good afternoon. Thank you, Chair Krishnan and members of the Committee on Oversight and Investigations for holding this hearing and providing us with the opportunity to testify. My name is Lucky, and I'm the Senior Civic Engagement Coordinator at the Asian American Federation, where we proudly represent more than 70 member organizations and serve 1.5 million Asian New Yorkers. We also convene the Rapid Immigration Support and Empowerment Network, a network of nearly 20 Asian-led and Asian-serving organizations providing immigration case management and legal service support to New Yorkers. As we've all talked about earlier, the current administration has brought drastic policy changes at the federal, state, and local levels. ICE's brute and indiscriminate tactics have shattered families, instilled fear, and prevented New Yorkers from accessing essential services such as law enforcement, public benefits, healthcare, and education. This is verified by our member agencies who have said that many of our community members have stopped accessing public benefits, and even things like food pantries. They're just, yeah. And yeah, our New York City sanctuary laws are in place to protect immigrant New Yorkers, yet recent events indicate these protections were not upheld. In September 2025, a New York City corrections officer provided federal immigration officers with real-time information about the release of a man from Rikers. This led to his arrest by ICE in late October 2025. ICE conducted a military raid on Canal Street in Chinatown, arresting 9 immigrant vendors and 5 protesters. And then on November 29th, the NYPD helped ICE agents push citizens out of the way while arresting more than a dozen protesters. Raids are only expected to escalate throughout the year, creating fear within our communities in the city. With the threat of militarized violence in our city and the lack of protection and training for NYPD officers, immigrant New Yorkers' rights continue to be violated, and individuals with lawful immigration status continue to be detained without due process. As immigrant New Yorkers face heightened threats, we must prevent local and state law enforcement agencies from diverting resources to the federal deportation agenda and sharing sensitive information with federal immigration authorities. Here are our recommendations. We support the following recommendations to protect immigrant New Yorkers. Protect and expand funding for the following initiatives: legal services for AAPI communities, legal services for day laborers and domestic workers, and immigration legal services for survivors of violence and gender-based harm. Expand investment in language-accessible legal services to include and prioritize case management as our CBOs act as a critical bridge. Prioritize supporting small and mid-sized CBOs serving emerging immigrant communities, and prioritizing addressing contracting issues that pose barriers for CBOs to promptly receive funding to deliver their crucial services. We must work together to make sure that immigrant New Yorkers are aware of sanctuary city laws and what that means for them. We also need to work to provide protections and options for immigrants to pursue when they are affected by unlawful cooperation between city and state agencies with federal immigration enforcement agencies. This is how we can assure that New Yorkers feel safe in their home. Thank you for allowing me to testify, and we look forward to working with you to make sure our immigrant communities get what they deserve.
Thank you all for your testimony. We'll now call up our next panel, Gabriel Rivera and Jennings Yusuf. Jennings, yeah. You may begin.
Again, at the wrong spot. I called your office, sir, this week because I wanted to speak on a topic. It's a stalking issue. And I called the deputy speaker's office because I wanted to speak on a topic. One got back to me, the other one didn't. May 11, 2006, stalking issue started. Raymond Kelly, the police commissioner, and the wonderful Bloomberg, and the wonderful DOI that was here that I reached out to for 10, 15 years, and so many others. And while I was here, I'm not well. I'm working on my third heart attack due to this creeping around and whatnot. I don't understand, and you're an attorney. I'm lost at all of this. But it's just about sanctuary cities today? This is what it's about.
That's the topic of this hearing. So if you have any testimony about sanctuary cities, that'd be very helpful.
And I tried to get information when I called your office and another office to talk to someone about whatever, but I couldn't get through. So I'll make it brief because I spent 3 hours here. I'm not well now. And it's a stalking issue. I'll make it brief. And I don't understand it. I don't really understand because 5,000 letters have gone to 4 presidents about all of this creeping around, and so I don't understand it. And the wonderful people from the sanctuary city that you're concerned about, the people who are here without their green cards, when I go and do my wonderful letters, I'm mobbed by those wonderful people who don't have green cards. But I'm going to leave now because I'm quite slightly agitated, and I don't understand any of this because I did reach out to offices to find out what I could speak on. You understand? But it's a stalking issue that I don't understand. And I had a heart attack in 2024. Right after the heart attack, I reached out to somebody named Yusuf Salam. Then I don't hear from him. And then last year,
Thank you very much, Mr. Jennings. The clock has
meetings.
ended, so we've got to unfortunately wrap up.
Yeah, I know. Have a good day. Thank you.
Thank you. We have now our virtual testimony too. Remind everyone has 2 minutes virtually as well. And online, we've got Noor Subhani.
You may begin.
Good afternoon, and thank you, committee chairs and council members, for organizing this important hearing. My name is Noor Subhani, and I'm testifying on behalf of the Surveillance Technology Oversight Project. I'd like to take this opportunity to highlight 2 initiatives that go hand in hand with strengthening the efficacy of the city's sanctuary laws by limiting the invasive monitoring of our communities by police, as well as information sharing with federal immigration enforcement. First, we must abolish the gang database and prevent data sharing with ICE. As was mentioned by my fellow panelists, the NYPD maintains a notoriously racist gang database that disproportionately profiles and criminalizes Black and brown youth. One of the most serious concerns is information sharing with ICE. ICE often accesses municipalities' gang databases to conduct raids, then charge or deport the people they detain. A recent investigation uncovered that the New York State Police gang database has been merged into a federal gang database, which is then funneled directly to ICE and used to identify immigrants for deportation. We urge the City Council to pass laws abolishing the gang database and preventing successor databases from taking its place. And at the very least, we must ensure that ICE is not given access to the surveillance profiles contained within this database. Second, we must dismantle the domain awareness system. The domain awareness system is a tool of pervasive and intrusive surveillance of New Yorkers. It links citywide camera networks, license plate readers, drone and helicopter feeds, shot spotter gunshot alerts, 911 and 311 call records, and other law enforcement databases into a single surveillance network. Every NYPD officer has easy access to the DAS on their smartphone and can share this information with federal immigration enforcement. In 2019, documents revealed that ICE uses the DAS data to create watch lists tracking undocumented immigrants. The DOI's December 2025 report highlights just how dangerous the DAS can be in the case of Liqa Kurdiya, where NYPD shared with ICE a DAS report.
Thank you for your testimony. Time has expired.
That included information on 2 summonses.
You can
she
finish.
had received.
If you can't finish quickly, be good.
Yeah, just to say that the DAS report included information on her student protest activities, and ICE used that information to support her immigration detention, which highlights the chilling effect on First Amendment rights that New Yorkers have. Thank you for the opportunity to testify.
Thank you for your testimony and important words about this issue. Our final online is Christopher Leon Johnson.
You may begin.
Yeah, hello, my name is Christopher Leon Johnson. I saw the pictures outside that you guys posted with the Street Vendor Project and the NYIC, the Worker Justice Project about the thing, and I'm surprised that none of you guys really are not calling for the firing of the commissioner, Jessica Tisch. She is the root of all the reasons why that Madani, our mayor, cannot even do what he promised to do when he's running for mayor with not collaborating with ICE when it comes to detaining the low-hanging fruit of the city, which are the baristas and the street vendors, and many of the low-hanging fruit. The city council has to, like I said many times last session, and this year, I'll say it again, that this city council need to come out with a statement and tell Madani that they need to fire this police commissioner. She's the reason that the sanctuary city situation is going to keep on occurring for the next 4 years. We're going to have more migrants in the city getting detained and deported, especially the low-hanging fruit are the baristas and the street vendors more, because of this police commissioner. This police commissioner is pro-cop, and she loves Donald Trump. So the city council, going forward, I know next week we have the immigration hearing, and then we have the immigration for oversights like that. But starting you, Mr. Kershan, you got to start calling for the mayor to fire Jessica Tisch, because once she gets fired, we'll have a better chance of really making it the city to the real sanctuary city that it should be. And these nonprofits got to start calling the stuff out, have to come together to do the same thing and start calling out Jessica Tisch, but they won't, because they're scared of the backlash, and they know that that lady has a lot of money to make them get them in trouble, and they don't want to settle up the fire from Jessica Tisch. They're scared of her. I'm not scared of her. I mean, but these nonprofits like the WJP and Street Vendor Project and the NYIC, including City Council, need to all come together and start saying the right thing is fire Jessica Tisch, fire the NYPD.
Thank you for your testimony. Time has expired.
Thank you so much, Mr. Johnson. Appreciate it.
Thank you.
Okay, we have now heard from everyone who has signed up to testify. If we inadvertently missed anyone who would like to testify in person, please visit the sergeant's table and complete a witness slip now. If we inadvertently missed anyone who would like to testify virtually, please use the raise hand function in Zoom, and a member of our staff will call on you in the order of hands raised. I will now read the names of those who registered to testify but have not yet filled out a witness slip or appeared on Zoom.
It's just making sure these folks
It's Zachary Ahmad and Gabriel Rivera. Seeing no one else, I would like to note again that written testimony, which will be reviewed in full by committee staff, may be submitted to the record up to 72 hours after the close of this hearing by emailing it to testimony@council.nyc.gov. Thank you all so much, and that concludes our hearing. Thank you, Co-Chair Brooks Powers.